mentioned today. Yes. Sorry, yes, Mr. Hussain. Yes.
I would like to mention the Ilahi box versus
Sir, is it in the monthly list or in the supplementary list? Tell me.
supplementary list.
Yes. Which matter?
Maintenance.
Item number?
Item number did not mention, but
Sorry, ascertain and come back. Yes.
For inclusion. For
Which
inclusion
list?
the month in the daily list.
Where are you mentioning from? It is part of the list.
For
No, don't mention today.
Lordship mentioning for monthly list,
No,
expeditious
madam,
list.
sorry. Yes.
For expeditious disposal.
Monthly list, I have already on the last occasion, it was over. Yes.
This matter was heard by the vacation bench. Well, no urgency, but there is an urgency. Urgency is that on the 1st of February, my lord.
For inclusion?
Yes,
No, don't mention today. Next month. Next week, third week, you will mention for inclusion. So that will come up in the next list. Yes. Sir, is it from the monthly list? Sorry, sir. Yes, next. Item number of the which list? Yes. Hand over, yes. Hand over, yes, madam. You are the assigned matter. Kindly wait for a while. Let me go through the motions. This month, unlikely. There are too many holidays, madam. Next month, you mentioned on the first Monday, I may allow all mentionings from the monthly list. Thereafter, I don't allow it. Now I'll allow from the supplementary list. Otherwise, it will be very difficult. Every day I have to take mentioning till 12:30. Next month, madam. Yes. No inclusion today. Yes, sorry, sorry, mister. Next day. Sorry, sir. Next. Yes. Yes. Daily list. Yes. 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 Sorry, sir. No, not today, sir. You can't mention it just like that. Listed motion. When did you file it? So, you ought to have come up initially at the month of January, first date, sir, when the matter was monthly list was published. So you did not come then, sir. Yes, you have to wait now. Yes. Yes, madam. Yes, ma'am. Yes, sir. Yes. Which list? Which list? Yes. Sorry. Yes. Which? I allowed your mentioning. It's over. Yes. Sir, which list, sir? Please tell me. So no, sorry, don't mention today. Yes. Madam, what were you doing for inclusion? Next date is 18 January. When did you file the matter? So why did you not mention earlier? When the matter did not appear, mention on the third week so that it appears in the next monthly list. Yes. Yes. Which list, madam? No, sorry, madam.
Lordship, due to extent parties, Lordship, my matter is running in the monthly list, Lordship.
Yes, sorry. Yes. Did you not hear what was read out? Yes. Anyway, which list, sir? Why? If this continues, I'll not take up the mentioning, sir. If this is repeated, I'll not take up the mentioning. Don't you understand? Yes.
For inclusion that daily list, you were supposed to come in that list on 8th of January. Didn't come. Hence, I'm confident to come.
8th of January.
My lord.
8th of January.
That's how the listing on the file.
Very well. So it's after the monthly is mentioned. Yes.
My lord,
The other listing.
Not in the monthly list, not in the daily list, your lordship. I have filed on 9th January, your lordship. Yes.
My lord, for correction of my lord's order of
Yes,
3rd
hand
of
over.
January.
What is the correction?
My lord, certain inadvertent errors of my lord crept in factual. I've indicated that, my lord. But this was my lord, the civil revisions, my lord, Mr. Mukherjee and Mr. Kaur, my lord, were argued.
Yes. Which part? Which part?
Yes, my lord. My lord, the cost title, my lord, that the first page, my lord, the next, my lord, kindly turns to page 4, para 5, my lord. I've indicated, my lord, that in blacking. Page 4, my lord.
Yes,
And
yes.
then, my
yes.
lord, at page 8, my lord, para 8. The figure, my lord,
Eight,
there's
okay,
one.
Figure.
Yes, my lord, that's the total outstanding, my lord, the society.
Now, I've directed this to proceed before the trial court. They
Yes,
must
my
be
lord, yes,
proceeding.
my lord. My lord, the
So this
sec,
should not hold back.
no, only those corrections, my lord.
These corrections will be done. You should not hold back the direction.
No. It is not, it is no way affecting.
These
my
are
lord.
figures, only
Yes,
in
my lord.
figures.
Only innocuous, my lord.
Yeah, I did you.
Application for
Grateful.
restoration, my lord.
Restoration. When was it dismissed? When was it dismissed? You are not aware. Forget it. Yes.
Yes, it was supposed to come on 8th of January, your lordship. In the
8th of January. Sir.
Eighth.
7th, we had a mentioning কবে ছিল আমাদের? It was couple 7, Sorry. Yes. Yes, next mentioning. You don't follow what is being said, sir, in court? Yes. Sir, next week, sir. Kindly mention next week. I'll take it up. I'll place it in the list. Yes. What? When did you file the matter? Yes, sir. Sorry, refused. देखी. Why are you handing over? I did not grant you leave. I did not grant you leave today. Sorry, sir, I did not grant you leave. Please understand, I did not grant you leave. It was supposed to appear when? Sir, it did not appear. Did you mention on the first date? Did you mention on the first date? You did not. ফেরত দিয়ে দাও কাগজটা. Yes, sorry. Yes. Mention on the 3rd week, sir. Yes. It will appear. The file has not been traced out. It will appear. Very well. Let it run. You know what is to be done, sir. Let this court not enlighten you, sir. What? You don't know when the executor ties no probate can be granted on that aware, sir? The executor has to come forward. He cannot be transposed. It is what executor has to come forward. No, sir. No judgment will help you, sir. The executor himself has to come forward. What are you saying? Sir, the executor has not come forward. You want to compel the executor to come? So what? You cannot compel anyone to come. Matter is the monthly list. No, sorry, sir. Sorry, sir. Sorry, madam. Yes, you did lost your chance earlier. Yes. Yes. Handover. Yes. Handover. Yes.
February, my child's birthday. I cannot see my child.
Yes, you mentioned this matter earlier. Yes.
That mayor will allowed to mention for inclusion, my lord. It was supposed to appear in the monthly list of
No,
December.
yes, sorry, madam. Yes.
Section of 1, section 24 matter. Non-prosecution of 1.
Handover.
Milord, this is the matter, Milord, which were appearing in the monthly list right from September 2024
Sorry, sir, madam. Sorry.
till Milord
I
December.
cannot help you. This is not the day for mentioning. Yes, sir.
Milord, it
For
is not
exclusion.
included. not included in the
It
list.
is not mentioned on the first date. Yes.
My lord,
It is on
let
the
it
month.
for inclusion, my lord, may I be
Sorry, not today, I will not allow. Yes.
Item number 29 of the daily supplementary. Item number 29 of the daily supplementary.
Yes.
Order 7 Rule 10 application has been rejected, my lordship, and the next date is fixed on 20th January.
So what happened? Order 7 Rule 10 application has been rejected for return on the ground of jurisdiction.
My lordship, not jurisdiction, my lordship, the matter relates to and consumer,
Order 7 Rule 10, sir.
Order 7 Rule 10. My lordship, it has been rejected. I'm praying for only one chance of hearing may be given, my lordship. May be included because the hearing is.
So what is the urgency? Order 7 Rule 10 rejection, tell me. What will happen if the suit proceeds for a while? No, what will happen? Has it been rejected? No.
It has been
No, it has not been returned. Your application has been rejected. Yes, wait. Next month. Yes.
rejected, my lord.
Means I did not understand, sir.
Matter is listed motion, right?
Sir, I understand listed motion. When did you file the matter?
The matter of 23, my lord.
20?
23.
I don't have determination. Yes.
You have determination is.
No, 2023 I don't have. Unless it is section 24. Yes.
You have filed this matter on 27, 2024.
Sorry, sir. Today is not the mentioning for 25th July matters. Yes.
This matter.
No, from which list, sir? Monthly list, sir. Sorry, sir. I have already allowed monthly list matters. Today is not the mentioning for a monthly list. You have to wait for the next month. Yes, sir. Arey, wait. Seniors are mentioning. What are you doing? Yes. Monthly list I am not allowing today. Sir, you have to wait till next month, sir. I have monthly list I allow. For 2 hours I take mentioning every month, sir. You have seen that. So today I am not going to allow monthly list mentioning. Yes. No, sorry. Yes. Anyone else? Yes. Monthly list? Sorry, madam. Do not mention. Any other mentioning apart from the monthly list? Yes. No, wait. Sorry. Not today.
Sir, IPR matters, though appearing in the monthly list.
No, sir. Sorry. Monthly list I will not allow today.
My lord, I
Yes,
was
any
praying
other
for
mentioning?
inclusion, my lord. Matter was to appear on the 10th, my lord. It did not appear.
10th.
Yes,
Handover.
your lord.
Yes, handover 10th.
Your lordship, the matter on August and still it is not coming in.
Sorry, not the date.
Your lordship, the matter was against, the matter is against the Bar Association, Diamond Harbour.
So,
Your lordship, the matter was about to be listed on 10th
do
of.
not mention. Already an order has been passed in this matter. Sorry, sir. Next month. Yes, call the list.
My lord, this is my matter. My lord, I am to mention, my lord, one matter.
Sir, it is from the monthly list.
My lord, one thing.
Please understand it.
My lord, first of all, let me submit, my lord, what I am to submit. My lord,
Read out one second. Please
ma-
read out. Please read out.
my lord, this is not my case. My case is, my lord, that the day, my lord, yesterday,
Please hear.
my lord, that
Please
I'm not saying, my lord, yesterday, my lord, that the district magistrate
Sir,
is
Odhikari,
going to,
you are senior advocate,
my
sir.
lord, going
Why
to
senior,
get one
sir?
yesterday. My lord, this is that, kindly see.
I will not accept it is from the monthly list, Mr. Odhikari.
That is not my question, my lord, that the question is, my lord, that if yesterday, my lord, I would not have disturbed your lordship because I filed it. I have instructed my junior.
Relax.
My lord,
Odhikari.
my lord,
Why
what I am
senior?
saying, my lord, that how the district magistrate has
Sir,
heard
Odhikari, hear
the
me.
matter is pending before the honorable court. Why
Hear me. You
go?
are too senior now. If you stress yourself, you will injure yourself.
No, my lord, it is true. My lord, I have never instructed my junior at least to come forward. Means it was filed on
Relax.
16th.
Why are you getting
But
excited?
my lord, you will also kindly see. My lord, how dare, my lord, that
Concerned
the
of your
district
health,
magistrate-
Mr. Odhikari.
my lord,
First
that the,
in
I
health.
have lost my all health because
No,
of
no,
this
no, Mr.
institution.
Odhikari, first in health.
And
Arey,
my
I
lord,
have
that the
known you.
district magistrate should not
I
be
have
there.
known you for ages.
Kindly see, my lord, that the yesterday, my lord, he has sub notice that
There is the matter. Monthly list.
my let me see, my lord.
So you do.
My lord, it is.
My lord.
My lord,
Date?
it is, my lord, that the item number 817. My lord, that it was not mentioned before your lordship. But my lord, it was intimated to
Sorry,
the district
Mr. Odhikari.
My
I
lord,
cannot.
kindly see, my lord, if my property will be, my lord, one thing, my lord, I am asking for myself as well as for the institution. My lord, at this age of 72 years, my lord, I am to learn many things from this honorable court. I am highly apprised of this honorable court. Definitely, I understand the problem. Had I been there, my lord, that there would have been more problem.
Yes. Yes.
This is magazine from that the magazine training here, we are a backlog of cases, avalanche of cases and books are facing. Now, therefore, don't take such a hasty decision, and my lord is still there, my lord. Even if that, my lord, that I have distracted the
scrutinized like all my personal and my lord, the yesterday they have some notice that my dear customer they will take my lord the point of my lord, under compelling circumstances, if a man asks you to be on board, then you want to take out an application, Mr. Odhikari. You know better what to do in such circumstances. Take out an application without the app. Take out an app. You know better what to do. Arey, Mr. Odhikari, you are so senior. On mentioning, I will not allow. Take out an application, I will allow. Yes, any other mentioning. Yes. Monthly list, I will not allow ordinarily. Take out. And Mr. Odhikari, one more thing. Please hear me. Do not, I repeat, do not stress yourself so hard. Arey, Mr. Odhikari, you are getting senior. You are not getting younger, Mr. Odhikari. I have seen you. No, I have seen you. I seen you for the ages, for over my years. When I joined the profession, I have been seeing you, Mr. Odhikari. Please don't stress yourself, Mr. Odhikari. Yes. File an application, what to do? Yes, sir. Not overburdened. I cannot take up these matters. Take out an application, I'll consider. Yes. Take out an application. I'll call monthly list, I will not hear you. Yes. Sorry. You file an application, I'll take up. Yes. You want a release? You say so.
But my lord, I was subjected to a similar because of the burden here.
For release. Why? I have to consider whether I can release the matter or not. Yes. Yes.
With jurisdiction, the determination lies at my law justice coming now was constituted.
So why did you file it here?
When I filed
The bench was not there. Are you sure, sir?
the bench was constituted and it came into existence.
I will consider whether or not to release it because after all, the 227, the scope is different. 227, sir. Why will I release the matter? You have filed a 227, sir. Justice Kapoor, the Honorable Justice Kapoor will not have determination so far as 227 is concerned. Sir, under 227, you have filed it, sir. Please tell me yes or no. Otherwise, this court will not have determination. Why will I release the 227? You have to take back your petition and file afresh. What are you saying, sir? So far as this court is only this court has determination insofar as 227 is concerned, current matters. Please understand what are you submitting, sir. You are quite senior now, sir. If it is an IPR matter, it has to be filed. Similar situation. Please understand. Similar circumstances, Mr. Ghosh moved the matter before this court. Then he found the determination was there. I did not allow it. So he filed afresh there. This application cannot be released. What are you saying? Sir, you think you can say whatever you want in court, sir. 227 determination is not there. 227 determination is with this court. Like arbitration matters, determination is with another court. But 227 is here. No, I will not release it on that. You have to take out an application in that case. 227, I will not release. Please understand, if you want to file afresh, go before that court and not press it. You say you will not press it. I'll permit you not to press. I can't release.
Whenever it's convenient for a
No, 227, I will not release. You say that I don't have determination, it is a different issue. So that is different, sir. Go before that court, sir. The honorable court has determination. I may not exercise determination at all. Pendency of the 227 will not act as a stay there. File it separately, sir. Yes, any other mentioning on this? What? Yes.
Well, this is
Sorry, sir, not so innocuous, sir. Your prayer is not so innocuous that has to be taken up, sir. Plus, please tell me from which list are you mentioning? I'm not permitting today. Yes, anything? Excepting those matters which are filed after 8th. Yes. No, I'm not. You have just heard, madam. Have you just heard what I said? I'm not allowing inclusion today. I'm not allowing mentioning from the monthly list. I have to repeatedly say.
Not appearing in
What will happen in this process, madam? In future, I will not allow the mentioning. I will only permit the learned advocates to file a written note of urgency, and I'll consider that. If this carries on, madam, I have my limitations. So I will not permit this at all in future. I will only allow you file your notes, Mr. Kormokar. I think this is better procedure. I will consider it. No, I will consider it. Because as an officer of my court, you are not in a position to use this opportunity. Despite the fact there is a note in the list that do not mention for monthly list, repeatedly mentionings are made on the monthly list. This week I've not allowed this. Please understand the situation, but repeatedly it is done. If you do, I'm not saying you're abusing it. You may have your limitations. You may be under terrific pressure, but the court has set a procedure. Please understand. The procedure has to be followed. But exceptions can be made. Exceptions can be made, Mr. Kormokar. Not that.
I'm on that.
But please understand, if this cannot be an exception. Exception proves the rule, correct? But this cannot be an exception. What will happen in future? From the next month, I've thought that I will allow everyone to put in a note of urgency and I will read it in my leisure and consider it.
Sir, if I may suggest one thing.
That is the best thing. Because otherwise it's not possible. You see,
If I may suggest one thing so that your lordship can manage, your
Yeah.
lordship knows much better than me, but.
No. Yes.
If your lordship can make certain hates, like expeditious disposal or
I will. Give me that time.
those can be.
Now I am only taking up urgent matters and I have been able to come up to April only. Let me come up to at least May. 6 months backlog, okay. More than 6 months backlog I am running. Wait, sir. More than 6 months.
The difficulty is not for getting in parity with those backlogs.
Perhaps will not be possible. There will be every day, at least 30 to 40 applications are being filed. At least 40. At least 40 applications are being filed. Please understand. The applications which I take up, I try to dispose of. The applications, some of the applications I fix on a particular date. The matters I cannot touch, bad luck. But matters which I can touch, I'm trying to make certain headway.
We don't have any.
Now, please understand, you have to also cooperate. Everyone has to cooperate with the court. The court cannot dispense. You are a stakeholder, mind you. You are a stakeholder in dispensation of justice also, and for access to justice for your client. So therefore, you have to also understand the situation. Yes. You have to mention last,
My lord,
Yes. So I cannot do, I don't have control. I have passed an order. What are you saying? The learned judge will decide the matter. Yes, this is a small correction. And this will not hold out the learned judge from deciding.
my lord.
Yes, Mr. Kormokar.
This is another matter for inclusion. For inclusion.
Next week, third week, I'll allow inclusions. Please wait, not the week.
Next
I have set a procedure. First week of the month, on the first date, I allow all those matters from the monthly list. I take up at least 2 hours to understand if there is any urgency and relative urgency. Everyone has urgency relatively, which cannot wait for the month. For the month, I decide and in a bunch, I prepare it. After that, I take from the supplementary list because those are filed subsequently. Those could not have been mentioned. So that is the procedure I'm following. Inclusion, I have allowed inclusions previously every month. This month also I'll allow. Please wait. This is not the day for mentioning of inclusion. Next month next week I'll allow inclusion. Yes. Yeah, I've disallowed your prayer. Yes. Sir, is it a man? Just heard, sir, what was there? It is for inclusion. I'm not allowing inclusion today. You have just heard it, sir. Again, you are mentioning. This is the difficulty, sir. It is better, sir. You put whatever you want. You write down in a note and everyone file to my office. I'll consider all your mentions. It is better, sir. Yes, yes, whatever you want, you file it. Or else mail it. It is better. Filing will not do. নাম দিয়ে দাও, mailটা দিয়ে দাও, কোর্টের mailটা দিয়ে দাও. Everyone mail. I'll be publishing in the list from Monday onwards. That you mail it. And I will accordingly hear. Yes, call
My
the
lord,
list.
may I
My
be
lord,
permitted-
My lord, may I be permitted to mention one expeditious hearing, my lord?
Whoever wants to
met
mention.
my son for 6 months, my lord. I've not met my son for 6 months, my lord.
Yes.
I've not met my son, my lord. It's a revision from a custody matter. My lord, can was pending last time when under the order.
Yes,
of the
which is
court,
your
I
item?
want to mention, my lord, there was a resistance from the father, and what has happened, my
Will-
lord, there was another can also that in that regard.
Item, which is your.
My lord, 1550 of monthly.
Yeah,
list,
I'll
my lord.
pick up.
I've-
Yes, very well.
I've-
Updated.
Infraction
Yes.
15.
My lord,
And
My lord, expeditious hearing.
But I am appearing for the opposite party.
Next month. Mr. Ghosh, Gupta, I'll remember next month. First day you mentioned, I'll remember. I'll place it up. You hand it over. I heard it. Which matter? This is which matter? Oh, this I was hearing. I take it out.
The HITCO matter.
Oh, this matter. Yes.
my lord, may I be
Take out an application. Sorry.
my lord, may I be permitted
If
to
you last, you'll mention last.
May I be permitted to mention one matter, my lord? This is regarding the recalling application filed by the executor of a will, my lord, which was turned down by the learned trial court, my lord. There was a stay, my lord, it was taken up for hearing.
Recalling execution?
My lord,
Recalling execution?
recalling of the evidence of the one of the parties to the original proceedings, my lord.
Why?
My lord, because
Recalling? No, not recalling. Recall of witness. Say so. Sir, say so, sir.
I can't.
Yes.
So, my lord, the urgency is that, my lord, the matter is.
No,
taken
recall
up.
of witness. Why? On what ground, sir?
The ground is very simple, my lord, that the opposite party who are contesting the original proceeding, my lord, they have the copy of the original will. Now that I want to adduce in the evidence, my lord, that is the only ground. That was not.
Sir, for
was
that,
not allowed.
anyway, please hunt up the Indian Succession Act. There are provisions by which you can call for
My lord,
that
I know
document.
it is a bit weird, my lord. Kindly take it away. It's a
No,
very
not by
interesting-
recalling. It is not permissible by recalling. Perhaps. You have to, first
Sir,
of all,
they have said so. They have said so. In their pleadings, they have said so. And in the
I mean, what
evidence-
will happen if the witness comes to the works?
My lord, the original will is in their custody.
So you know how to do it. That is not the procedure. This is not the procedure. The Succession Act provides for other remedy, not by a recall of witness. Anyway, I'm not placing it. You consider it and come back. Mention
my lord, the matter where I've been appointed as a special officer.
that.
Lordship, there's some personal difficulty for me to attend.
For the time.
My lord, my mother is not well. I have to take her to the doctors this particular week and the next 2
Very
weeks,
well. That is
Lordship.
no difficulty. I'll excuse you for this week.
For this week, Lordship.
Yes.
Then
Relax.
I'll make notices, Lordship, but the petitioners, the advocate is present. If I am not present, she won't be able to meet the child.
Madam, she has personal difficulties. Let the
I
child
understand. I
go.
understand
Let
the
the
matter.
child go and meet the mother.
The lordship.
She has personal difficulties.
Yes,
What are
I
you
understand.
saying?
I understand it. That is what.
And a person cannot have difficulties.
No. I'm not
You are
objecting.
for the, you are for the.
Petitioner. I'm for the petitioner.
Oh, madam, do one thing. Let the child go and meet.
My lord, may I suggest this?
Yes.
Tomorrow, as it is the matter is
Yes.
fixed at 4:30, if your
4:30.
lordship remembers to meet the child and the
She has some difficulty.
So tomorrow, my
Can't
lord, is-
compel her
I'm-
to
I'm
go
not-
every day.
I'm not asking
Let
that.
the, very well, tomorrow, yes. Very no
Tomorrow it is
difficulty.
there, my
Yes, you can meet visitation there.
No.
Madam, you relax. There is no difficulty.
So
And
tomorrow, my
you
lord,
need not bother so much. If you have any personal difficulties on a particular day, a person can have a personal difficulty. This is the reason why I said that
Yes.
this is a complication. Special officer will.
yes, your lordship, which is why I suggest, my lord, after tomorrow, because tomorrow is Tuesday, which is a visitation day.
Yes.
So tomorrow at 4:30, your lordship had called the parties along with the child, my lord.
Yes.
So tomorrow, after the matter, your lordship can decide what can be done or maybe.
No, I'll be seeking suggestions from you, Miss
Yes,
Lala,
your
also.
Yes, your
Because
lordship.
special officer I will not be discharging. But it shall not be under the direct special officer will be there. If necessary, she will go. Every day she will not be required to go and accompany the
It
child.
is 3 days a week, your lordship.
May not be
Tuesday,
necessary. Or
Thursday
the
and
special
Friday.
officer will be there. She'll be seeing whatever is happening around. She'll be having a tab. She'll be having the phone numbers, everything. But it's not necessary for the special officer to always go, perhaps.
My lord, till
After all, it's a minor child, madam, and mother and father, parents, you see, with the child.
My lord, perhaps after tomorrow, if your lordship.
Madam, this is not, you are not the only person who has
Yes.
given birth. There are other people who have become parents.
Yes, your lordship.
So there are others also. And in this world, madam, this is how it has been going on.
Yes.
So we are all, at the end of the day, crave for love and affection of our parents.
Yes, yes.
And
your
you
lordship.
cannot deny it also.
It cannot be denied. We are not coming in
So
the way of
find a ways
visitation
it
at all.
needs to, I will say that you give us suggestions how to resolve
I
it.
shall take instruction.
Yeah, how to resolve it.
Yes, yes. your
Not
lordship, I
to-
completely understand.
You see, there have been difficulties in the past. Relationship is sour. You cannot ignore this situation. This has happened. You have to move forward because the child is growing every day. Consider it, madam. You are there, you will consider this comeback, madam.
Yes, your
Tomorrow we will meet
Yes, your lordship. but
after
only
court
one
hours. Yes,
clarification
madam.
I seek, my lord,
Not
that
necessary
tomorrow is
for
a
the special
visitation
officer to
day.
go today. Since she's in
Tomorrow is the
She has
visitation.
difficulty today itself.
Yes.
Yes, this week. Yes, madam. No difficulty.
So for tomorrow, my lord, I'm seeking only one clarification because
You
tomorrow
bring
is a
the child
visitation day.
and you
After
come.
that, my lord will.
You will be there.
Yes,
You
your lordship.
personally also you will
I
be
will
there.
personally be there.
Please be there,
after-
madam.
Yes, yes. At
Because I will require your assistance.
Yes, your lordship, I shall be there. Only
And you
thing
will
is
be
that
there also.
6 to 8, there is a visitation on Tuesday. That is tomorrow. That is what I'm seeking
Yes.
clarification.
Very well. That court, after that, I will consider. I'll
My
be
lord.
there, madam.
That is what I want.
Unless I do not know things. Tomorrow, as it is, it's fixed tomorrow, madam.
Very well, your lordship, that is what I'm seeking clarification.
No difficulty, madam. Yes.
Grateful, your lordship.
Lordship, the urgency in this matter is the urgency of this matter
Hey,
is
the matter is in which list?
this is not in
Not mentioned. I'm not allowed.
but your,
Sir, I have not allowed
My
it.
My
lord-
lord,
I have to mention it next week, sir. Sorry, sir.
your lordship kindly
appeared 2 days.
Sir, you are too senior, sir. I have disallowed everyone. Sir. Sorry, sir. Kindly come.
You are senior.
Sir, kindly come next week, sir.
your lordship kindly appreciate
Any-
the
any
urgency,
day, any
kindly
day,
appreciate
Sir,
the
you also kindly appreciate the fact that I'm not allowing mentioning
but-
for inclusion today.
but your if
Yes.
if the matter is delayed then
May I be permitted to mention one expeditious hearing, my lord? My lord, the matter was supposed to appear on 10th of January. It has not appeared.
Yes.
Item number 40 of the deliveries matter was listed on 8th, my lord, for expeditious dispute.
8th.
8th of this month.
नहीं ना देख लिस्ट दिए दो 8 पे 8 दिए दो अच्छा तो list is there in the list. Why are you mentioning? It is there in the list. Why are you mentioning it is there? Sorry, it is there in the list. Yes.
My lord,
Otherwise, no, it
This
will
is
go in
my
the month list,
personal
madam.
matter, my
Yes.
lord.
Yes.
Your lordship, if matter is appearing as 1409, are the disposal matter, my lord. They are enjoying interim injunctions from 222, my lord.
Yes. Any other mentioning? Sorry.
My lord,
Yes,
item
madam.
number 1675, it has
Madam,
come,
I'm not allowing mentioning of monthly list, madam, today.
it has come wrongly under the,
Wrongly, under which head?
under expeditious disposal. It is an application under section 24,
ওটাকে চেঞ্জ করে দিও section 24 16
1675.
next month list it will be changed. Yes.
My lord.
16.
my lord,
হ্যাঁ হ্যাঁ section 24 বলে দিয়েছি তো not press দেবে সব yes
my
আছে
lord, may I be permitted to mention one matter, my lord, for expeditious hearing?
section 24 হলে আছে yes not press yes yes which list monthly list no sorry I not all yes sir
My lord, expeditious hearing, my lord.
I have disposed of your matter pending. Don't mention this month. They mention next month. Next month is again visitation when you have. When you have the next visitation. I shall see to that. Yes. Yes. Yes, call the list.
My lord, may I be permitted to mention one expeditious hearing, my lord? It was supposed to appear on 10th of January.
On the online platform. Yes, call the list.
It become infractious.
Execution stage, your lordship. I'll be
My lord, the list, the
Or
mentions list has been submitted, my lord.
online platform, madam. Yes, call the list.
Your lords. Become infractious, your lord.
Yes, wait. This, madam, you are only insisting for hearing of the contempt application. The learned advocate for the petitioner would submit that this matter had been mentioned. There was a part heard actually, I saw later. So I had to clarify the situation. Part heard, madam, was only limited to the section 17, was not in respect of the main matter. No. So I clarified the situation. Later on, even if I direct it to go out, it may be said that the learned judge might find that there is a recording of part heard. So I clarified. I have not heard, I have never heard the main matter.
I am appearing for the state.
We can add a line. The party shall be at liberty to take appropriate steps in the main matter. Yes, it appears that in the order dated paragraph, it appears that in the order dated 7 January 2025, in paragraph 9,
My lord, 6th December.
in paragraph 9, line number 2, the date of the order has been incorrectly recorded as 6th March 2023 in place of 6 December 2023. Let the same be corrected accordingly. Other portions of the order remains
Okay.
unaltered.
My lord, there is 3 others matter, my lord.
Those have been correctly uploaded.
No, my lord, till.
Those are correct. Those were not uploaded.
Okay.
It was already detected. This was already uploaded. So I had. Those were not uploaded. So that's this has been uploaded, therefore it is corrected. Yes.
Lordship, I am led by learned advocate Mr. Prosenjit Mukherjee.
Do you want to do the matter, madam? Madam,
Lordship.
please continue.
Lordship, this is the affidavit of service.
Yes, very well. Affidavit of service. Why?
The extension of interim order, Lordship.
Extension of interim order. When did the interim order expire, madam?
On 30th 11 2024.
And what were you doing thereafter? You forgot about the matter. Yes, madam. Affidavit of service filed in court is taken on record. Full stop. Service is complete according to you. Have you checked up?
Lordship.
They have received it. देखिए अब बताओ. Despite service, none appears on behalf of the opposite party. On behalf of the defendants stroke opposite parties. Full stop. The instant application has been filed. Inter alia praying for, in effect, reimposition of the interim order passed on 24th July 2024. Full stop. Miss, what is your name?
Tiyasha Ghosh.
Ms. Ghosh, learned advocate appearing in support of the aforesaid application, by drawing attention of this court to the order dated 24th of July. Next week, next week. Sir, when come?
Lordship.
Monday, next Monday, not this week.
I appear for the parties.
Is a caveat?
Yes.
I file a caveat?
There is a caveat, my lord.
Yes.
I'm praying for short passover.
No passover, sir. You are there, I'll hear you. Yes.
My lord, an order of trial court.
You are there, I'll hear you. Siddhartha Banerjee is appearing.
The Lahiri is appearing. And he's in code number 36. আরে আমার তো একটু সময় লাগবে আমি শুরু করি
No, it won't take time.
10 minutes, my lord.
Yes, urgency.
My lord, urgency is, my lord, police help order, my lord, on the basis of this order, which has been passed in the misappeal, my lord, there is an order for implementation. By
Naturally,
police
sir,
help.
you are not complying with.
My lord, lordship will be surprised to see the, my lord, prayer. What is the prayer in the application and what is the order passed? That
Misappeal, who
itself is
preferred the
sufficient to.
misappeal? Who preferred the misappeal?
My lord, we preferred. We lost before the trial court in the injunction petition. My lord, prayer was in the injunction. Kindly takes, my lord, the application.
No,
my lord.
misappeal has been dismissed.
Yes. No, kindly takes the prayer in the injunction petition once. Kindly comes to page 35.
Where is the injunction order?
My lord, that order is at page.
No.
56.
You have annexed the original. You have.
I have. My lord, this is, my lord, affirmed by the order of affirmation by the, my lord, first appellate court. So therefore, my lord, the certified copies are there.
Where is the first order passed by the trial court?
That's 56.
Certified copy,
56.
certified copy.
I am not, my lord, I am challenging the order of.
Both.
My lord, I can file, my lord.
You have to file.
I'll do that. But my lord, kindly hears me, my lord.
Mr. Dotto,
I will file.
your record ought to have brought this. Ought to have brought this. Without this, no interim order can be passed. You are aware of this.
My lord, kindly. Kindly sees, my lord, page, my lord.
It has been upgraded. He ought to have brought this today. You know, that is also an order certified.
My lord, I give an undertaking. He is here, my lord, we will file it.
When will he file it?
My lord, kindly comes to, my lord, page 30 once. Gives me, my lord, only 5 minutes, I'll explain, my lord. Page 30. This is the injunction application in a suit for declaration and injunction in respect of a property, which is, my lord, apparently as per plaint case a boundary wall.
30.
Is there, my lord, injunction application before the trial court?
It should directly come to the order.
Acha. Then, my lord, kindly, before I
Yes, I've got the order.
I have to show, my lord, the prayer, my lord. That is very important.
Yes, show me the prayer.
Kindly comes to, my lord, page 35. 30, the injunction application starts. 35 is the prayer. Temporary injunction restraining defendant, his main agents, from forcibly, illegally trying to stop any work of reconstruction of the boundary wall on B schedule property. This is the prayer. Kindly comes to the order at page 56. My starts at 56, kindly comes to, my lord, 58. He has filed documents in support of his case, my lord. Then, my lord, he refers to the learned trial court, refers to the written statement, not important, turns the page, comes to 59, his finding. 59, at the first paragraph, my lord, just after 6 lines, defendant also stated that there never existed any wall and 6.61 acres of land let out to Titagore Paper Mills Company Limited was never bounded at all. Defendant also claimed that instant suit and story of alleged boundary wall is an afterthought and a mechanism for ousting defendant number 1 from possession of the said land, measuring such and such without due process of law. Now kindly seize, my lord, last para.
I've seen that injunction restraining you from interfering with his position.
No finding that the plaintiff is in position. The prayer is, my lord, I have shown, my lord, the prayer.
Today, you see, the order is that restraining them from carrying out. Mr. Bose perhaps mentioned this matter on the ground that in the guise of this order, they are constructing a boundary wall.
No, they are trying to, my lord, demolish now my boundary wall on with the aid of this order and
Yes,
trying
sir.
to take position. And misappellate court also.
Wait, sir. Today, matter has to be heard, not like everything will be heard today.
Some protection.
Yes, sir.
Short pass over. I'm not the advocate and recording judge. I have not been instructed in.
That's why I told you initially.
10 minutes short pass over, my lord. He will be
10
here.
minutes, 10 minutes, 10 minutes. Ask him to come, ask him to come, ask him to come. Because one more disclosure has to be made to him also. Two matters are there. Same, identical. Next matter is
5 is, my lord, that implementation order under challenge. So if this goes, my lord, then that.
Sir, kindly inform me and do not leave the court also. You will be here. You do not leave the court. Yes. Inform him and come back. What is your name? Yes, inform him and come back. Yes, madam.
Lordship, I'm appearing on behalf of the opposite party. This is that matter that both the parties there. is a
For the
settlement
petitioner,
talks-
your lordship will recollect.
Lordship, there is a settlement talks. going on.
Settlement. Yes,
Lordship,
yes.
the
Your lordship will recollect.
LCR in this matter, no?
No. Lordship would recollect on the last date, Mr. Siddhartha Banerjee was appearing in 2 matters where the order 23 applications were filed and the trial court kept it pending for a very extremely
When did you
long
file the LCR in there? When you file the order 23, rule 3?
Well, this was filed in sometime in August 2023. And
The other matters, it was on 2nd of August.
yes, it's more or less same. And Malab, may I indicate the cause title in the cause list is appearing wrongly. It's not Oruna Doli. The name is something different.
Correct করে কালকে দাও।
It appeared to be.
এটা appellate side, so it is correct করে দাও কালকে। Correct করে দাও। First title ঠিক করে দাও। First title ভুল আছে বলছে, দেখে নাও correct করে কালকে আবার নতুন করে cost title দাও। It come back tomorrow, madam. Because otherwise the order cannot be uploaded. Same difficulty will be there.
I will indicate.
It has to be uploaded on this cost title only.
Yes.
So it cannot be uploaded. So
দিয়ে দে নামটা দিয়ে দে। আগে তো ছিল না।
কেন এখানে তো ভুল নেই, লিস্টে ভুল আছে। No, this is ADC. Oh,
Is there in the 975 in the monthly, the combined list, your lord?
cannot be next month only.
Some urgency.
No, how can I? Because supplementary list is only when you upgradation. You see, I've upgraded this.
Yes.
This will really a mismatch. You ought to have indicated this
So we
earlier.
had indicated it on the last date itself.
Item number?
975 your lordship's daily combined list.
No, this is an upgraded matter. Oruna Dolui.
Yes, Your Lordship. It is not Oruna Dolui, it is CO 70, if your Lordship kindly sees, is Ranjit Singh.
ও তো হবে না কিছু, আপলোডই হবে না order. দেখো যদি করাতে পারো, কারেকশন করে, নাহলে এটা তো হবে না, এটা নোট দিয়ে দেবো লিস্টে, যদি হয় তাহলে আমাকে কালকে বলো, তাহলে আমি come back tomorrow, ask your juniors.
Yes, yes, I will.
Madam, you also come.
Sir, I will indicate the correct cost title. My last mail.
No, it's there in the list, sir. Whether it can be done or not, because its monthly list has been published. Corrigendum to the monthly list has to be published. If it is possible, I'll do it.
But the only difficulty is I'm suffering an order of injunction.
What can be
in the
done, sir?
trial.
You ought to have checked up when at the time when the
But
list
we
was
indicate the
published.
first time we got to know, we indicated to your Lordship's officers also on the
And
last.
this is an upgraded matter.
Yes, yes. I understand.
The matter will not be uploaded. I can pass an order. The order will not be uploaded.
I understand that, sir.
This has to be corrected first. জিজ্ঞেস করো computer department কে, জিজ্ঞেস করো, ডেকে পাঠাও। হ্যাঁ, ডেকে পাঠাও। Yes, call the next matter.
I'm so grateful, madam.
Yes. এই নাম্বার 7 প্রশান্তজিৎ আসে কেন এখানে? প্রসেনজিৎ কে ডাকো তো না, ডাকো 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 ডাকো, নাম্বার 7টা কেন আছে? এটা আপগ্রেডেড নয়, এই নাম্বার 7 কি আপগ্রেডেড নাকি? কোথায় ডেট? অর্ডার কই? You are there?
7, yeah.
Yes. Why is it appearing as upgraded?
I'm for the petitioner.
That is different. Did you mention this matter? No.
Yeah, I have. It
What?
was upgraded and
What was the urgency in the matter?
for the visitation.
Oh, আচ্ছা দাও 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 দাও। ঠিক আছে দাও দাও, visitation নিয়ে দাও। Yes, move your matter.
My lord, I'm for the wife and petitioner.
Mhm.
And
What is your urgency? What is your?
in short, they were married.
And that's all right, sir.
All
Without
those
the
things,
marriage, sir, the child will not
all-
come,
all
sir.
those
So
things, there is a child and the husband has turned them away because of no male progeny.
sir, I cannot
all
go
those
there,
things-
sir.
all
I
those
cannot
things are-
decide all these
No,
issues.
I'm just giving a little bit. This,
Please
there
tell
will
me
be no
what has been
communication.
rejected. Section 12 petition has been. No, section 12 is fixed.
Yes,
Respondent permitted to visit the daughter. Who are you? You are the respondent.
yes.
Also, opposite party, father, you are the father. Visit the minor daughter in the house of the petitioner once a week.
I'm the petitioner.
At the time of visitation, you are the father.
I'm the mother. And for the petitioner.
You're for the mother. You agree by
I'm
this
the
order?
mother. He is present here.
Very well.
Yeah.
What are you aggrieved? The lawyer accompanying the lawyer?
I have already.
What are you aggrieved? Tell me, sir. I have seen the order. Accordingly, the petition for visitation is partly allowed. Weekly visitation and the prayer is rejected. You don't want your daughter to
want the
meet
lawyer.
father.
We don't
Lawyer.
want the lawyer.
Anything else?
One. Number two is too frequent thing for.
What too frequent? I'll permit it every day, sir. What are you saying?
Lordship.
How old is the minor?
It's going to be 4
So
years.
you
now.
don't want the minor to come in contact with the father?
Not the least, my lord.
Then
The question is, they are just hardly 2 kilometers away, and in 3 years, they
So-
have not found one day even to send a birth.
please understand, he's a biological father.
Absolutely, your lordship.
Is he not entitled to?
Absolutely, he is entitled to your
Yes.
lordship. This is on case to
So
case. We have
that's
to
the client
judge.
to keep all this aside.
They have been turned
For the
away.
child, some sacrifice is to be done. They may be having a very bitter relationship,
Yeah.
may be having,
It is.
but she has to sacrifice a lot for their minor daughter. Now the father is there.
Absolutely.
The father is entitled to visitation rights.
I agree. I agree.
The
your lordship.
lawyer, you are appearing on the other side. Let a copy of
only
the
humble
revisional
request
application
is-
be served on the opposite party.
Little less frequent, your
Oh no, let a copy of the, I'll
But-
hear you later.
But
Let
then
a copy
at
of the
least leave
revisional
the lawyer
application.
aside, your lordship.
Yes, I'll stay that. Let a copy of the revisional application be served on the opposite party. Very well. 4-year-old, I'll permit the father to take the child to his residence. It will be better for you. Lawyer will not be there.
The how that would
Why
be,
not?
He has not come to the meet the child once in the last 3 years,
So
your lordship.
therefore, it is all the more necessary, sir.
There are cases, many cases going on, and there is a police
No
case going on.
cases between with the child. No, case with the child.
Can
On-
compartmentalize your lordship.
No, please understand the situation. Sir, I am only dispensing justice for the parties. What I can do, I can pass certain orders. But please remember, it is for you. Means you means your client.
We have agreed.
To ensure it is for your, nothing so special. It is for your client to ensure that the minor daughter gets attention of the father.
Absolutely, your lordship.
And
I agree.
one day the child will grow up, sir,
I agree, your lordship.
and will be having enough words to question
Yeah.
what has been done in the past.
We don't deny.
So be careful of the situation. Remember, this is not the end of the road. Tomorrow this child will grow up and put forward many questions. So be prepared then also. So then you can say, no, I had not stalled anything. I had always permitted
I
the
fully agree,
situation.
Your
So
Lordship.
therefore, try and understand the situation. Yes, lawyers' presence may not be very congenial, very
Conducive.
conducive, and lawyers' presence will not help the parties. Maybe,
Yeah.
maybe. I'm only saying maybe. I do not know what is the situation like. But at the end of the day, your client is also required to cooperate. Let a copy of the revisional application be served on the opposite party. This matter for further consideration under the same heading. How soon can you serve? How soon can you serve?
Beg your pardon, your lordship.
How soon can you serve?
How to?
Serve.
I'll serve them on the, I'll serve on them. I've already
Ensure
served-
service. If they do not
I've
come,
even served the thing, notwithstanding, there is no caveat, I've served for today also, your lordship.
let a copy of the revisional application be served on the opposite party. List this matter for further consideration on the same heading. Tuesday date diye do. Next Tuesday.
Great.
Yes, call the next matter. Yes, Mr. Lahiri is there. Call the password. Mr. Lahiri. Ajay, first of all, I should tell you that this matter, this Titagarh, I had appeared for several matters for Titagarh, but
Not in
like
connection
no,
with
no,
this.
correct. But like Eastern Coalfields Limited also, but several other authorities I have appeared. So I have been taking up these matters unless anyone objects. So I'm just indicating to you. Yes. Now tell me, there is an order passed by the learned court granting an injunction in your favor. Fair enough. Allegation is on the strength of, I'm not going into other things, I'll hear your petition. Allegation is on the strength of the order of injunction, you're trying to demolish a boundary wall. Is it correct?
No.
Not correct? Very well, fair enough. Then I will hear the revisional application. The miscellaneous appeal has already been dismissed. So I will hear out the revisional application. In the meantime, you will not take any steps for interfering with the boundary wall of the opposite party, of the petitioner.
Petitioners.
I'll hear out as a returnable motion in the monthly list of March.
What is the prayer of the plaintiff?
No. You did not seek for a prayer for demolition of a boundary wall. I've seen that. Correct. And you say so. I'll record your submission. And I will also, this limited protection they are seeking, I'll grant that protection. So far as your injunction, I'll not interfere. Your injunction you enjoy. Your injunction you enjoy. Naturally. But you will not break down his boundary wall. Only this much.
His boundary wall.
Naturally. His boundary wall. Why will you break down? For today, that is the interim order advice Mr. Datto can get. Because this was mentioned on this ground by Mr. Bose.
Very well.
This was
Very well.
mentioned by
Very-
me
I-
on this ground of
very-
urgency.
Very well. I agree.
Anything else?
No, my lord, this protects me.
Ashok. Yes, it's nothing. That was mentioned by Mr. Bose. I had accepted his mentioning on the ground of urgency because his boundary wall is being broken open by your client, interfered. You say, correct. Having got the the instant revisional application and Mr. Bose, first of all, you undertake.
Undertaking by Monday.
At the very outset, Mr. Bose, learned advocate and record. Mr. Bose, the learned advocate and record, representing the petitioner, undertakes to file before this court the order dated, the certified copy of the order dated 27th of November 2020.
That's the trial court's order.
Yeah, naturally, you have to file these are the miscellaneous
Yes,
from
yes,
that
yes,
order.
yes.
27th of November 2020, passed by the learned. Civil Judge Senior Division, Third Court, Barasat, in TS number 906 of 2018, on or before the matter is taken up next. Full stop. Challenging the order passed
trial court that
Yes,
has been
I
allowed
mean,
and police help. So, my lord, in
naturally.
view of this order, this really becomes academic.
Why?
So, my lord, police help, my lord, if there is a status quo today, they cannot implement that order.
Why? They have rest you the court. I have not interfered with their position.
ঠিক হচ্ছে না।
No, why?
No, my lord, kindly seize the
Is
next
it your case
Kindly
that
seize the
you
next
have
order once.
is it your case, Mr. Dotto? Please tell me. Please tell me very clearly. Is it your case that they have encroached upon your portion?
They're trying to.
Trying to. They have encroached? No.
Not yet, that they were
The-
trying to. My lord,
The
just
court
give me
has-
1 minute,
court
I'll
has
explain what is
restrained you
happening.
from interfering with his position.
Yes. Yes.
Correct.
And in the process, what he is doing, he wanted a prayer that he should be, defendants, as in my client, should be restrained from disturbing him from reconstructing a
That
boundary
he
wall.
wanted
That was
that.
his prayer.
Court did
But
not
court
grant
did
that.
not, court granted something
Very
absolutely
well.
different.
Very well. Court granted different order.
Yes, now he is trying to implement that order and raise a
Mr.
boundary
Lahiri has
wall.
been very candid enough and said no. What
So,
more do
in
you
view
want?
of the status quo,
So I
my
will
lord,
record.
can this order be
Having
implemented today?
Having regard to the দাও পরে পিটিশন হ্যাঁ লেখো একসঙ্গে দুটো হবে having regard একসঙ্গে দুটো পিটিশন একসঙ্গে having regard to the order passed in CP in CO number 4149 of 2024.
Kindly seize order number
I am
44
of the
there.
view that no further order requires to be passed in CO 4150 of 2024. Let both the applications appear
Very well. This
be
will
taken up for
suffice.
consideration
On
together.
status quo, then it will go.
Unnecessarily
Yes, yes, I understood. I understood. This will
complicating the
suffice.
situation, Mr. Yes. And now, what did you expect? A detailed hearing on the first date, Mr. Dotto? You wanted the junior to
no,
a
I
detailed
thought-
hearing so that rest of the day is gone. All the
No, I felt lordship may go into the.
What is going on, Mr. Dotto? There are so many matters.
Yes.
Now,
We
unless
saw the mentioning, my lord, the
no,
queue
today,
there.
today is only the second day. The first day of the month mentioning is the he was it's
My
a
lord,
very
two
difficult
courts,
part.
two courts overburdened with this, my lord. One is the revision court, one is the residuary writ court.
But
My
you
lord,
have to take up matters.
mentioning, my lord,
But you
going
have
on
to take
till
up matters, Mr.
lordship has
Dotto.
to.
You have to ascertain relatively which matter is more urgent. More urgent. I tell you, all the matters are urgent. Matters filed in April, you consider that is
For
not
every
urgent.
lawyer, his matter is urgent.
No, not
Lordship has to.
different. Matter filed in April is not urgent. When I started, I was in January. Today, I'm in April, mid-April. So make some progress up to 2 or 3 months. Let us see how it proceeds. Yes, yes.
What my lord said that prayer and petition different and then cut paste, error of cut paste.
I forget it, sir. You are protected today. He is protected. Both are protected today.
Second point is, my lord, when we joined, when parties were present, there was scope of interim order, then contested application. Threadbare hearing never took.
No, some matters,
Only some
no
matters.
commercial court matters I am disposing of. The other day, I had disposed of a commercial court matter. Commercial court matters cannot wait.
Some matters can be disposed of in the.
That is different. But commercial court matters, like custody matters, these cannot wait. Yes, call the next.
Grateful,
matter. না একসঙ্গে অর্ডার করে দাও মাথায় দিয়ে and Mr. Bose, both the matters bring the certified copy.
No, the other one is directly from the.
Oh, directly. So far this is concerned, bring the certified copy.
That's to file.
Yes. Yes. ওপরে
my lord. This is transfer of a partition suit. Transfer of a partition suit. My lord, reason, my lord, I have stated in paragraph 2. It was considered by my lord on last Monday. But my learned friend have proposed for 2 places, that is at Durgapur and Katwa.
Yes, madam.
My lord, I am sitting.
They are,
My lord,
my lord,
my lord, kindly consider paragraph 2. My lord, kindly do not take me otherwise. Paragraph 2. What are the reasons for seeking transfer? Yes, my lord. My lord, nobody is accepting my brief, my lord. That is the wholesome problem.
my lord, I received my application of some paragraph. My lord, I have retired since 2008, my lord. Yes. Yes, my lord, but it's not full stop. My lord, for a moment, my lord, kindly allow my lord. Why para 5, my lord? Kindly. I have, they are stating that I am the bench clerk for the court. But I
No,
have
that the
retired my lord.
designation might be.
That is why I have stated in the para that if your lordship kindly transfer the same, then I am 76 years and 72 years. Then your lordship kindly transfer the book court or Kapua court or book court or my lord Kapua.
Yes, my lord, kindly allow me. My lord, kindly. Well, in both the proposed places, I have taken instruction from my client over phone. The no. My lord, 30 seconds, my lord. My lord, he in the I will, my lord, definitely, my lord. No, my lord, no. My lord, in both the proposed places, he was an employee. In both the proposed places. My lord,
No, my lord, I am paying transfer to Kapua or to Kapua. Yes, my lord, I have no problem. I was an employee at Bardwan Court, my lord. And retired. No, Kapua, not Bardwan. And I have retired since.
so, my lord, my lord.
My lord, my objection is, my lord, by taking this meeting at this.
My lord, in that event, my lord, in that event, Kalna, my lord, in that event, Kalna is the closest. Kalna is the closest. If that be so, my alternative. Much obliged.
Well, kindly similar amendments have been refused. Postal address was written premises. Postal. Yes. No caveat. No. No kind. Amendment refused, but only postal address has been given. Instead, the premises number, which is in the corporation 111. Instead, 25/1 it has been written. That has been refused. Yes, my lord, kindly see that only thing. Kindly see. Yes, my lord. Yes, my lord. I tell you, kindly see. The application kindly see, my lord. Yes. No, the PW1 during examination it was found that premises number is mistaken. Typographical mistake, somewhere 11, somewhere 111, somewhere 25/1. Good. My lord. No, because no, time was spent for imposed cost.
Make please, Your Lordship. Lordship, I'm being here from behalf of the petitioner, my lord. I'm being led by Mr. Ujjwal Rai, my lord. My lord, on earlier occasion, my lord has been pleased to hear this matter, my lord. This is an application for expeditious disposal of the title suit. And my lord, on earlier occasion, my lord, two last few orders were not there, where my lord has been pleased to adjourn and asked me to, my lord, bring these orders, my lord. My lord, this suit is in pending from 2016. And my lord, this is in the last stage, my lord, of evidence is going on, my lord. And my lord, no interlocutory application. My lord, title suit, my lord. Title suit for permanent injunction, my lord. And it, my lord, it is, my lord, no interlocutory application is pending. My last, my lord, on PWD1, my lord, is going on. Suit for, my lord, permanent injunction under section 38 of Specific Relief Act, my lord. Okay. Chief, my lord, cross of PW1. My lord, it will be, my lord, 12th September 2023 onwards, my lord. My lord, last order, my lord. G. My lord, further examination, PH, my lord. Yeah. I beg apology, Lordship. I'm my lord, on 11th November, there was a local bar resolution, my lord. My lord, and plaintiff have filed Hajira. My lord, plaintiff have filed Hajira on my lord, 5th July, my lord, the adjourn, my lord, as my 11th. My lord, my lord, appear, my lord. My lord, Hajira has been filed, my lord, on behalf of the my lord.
Having regard that I am not inclined to pass any order for execution.
My lord, kindly, my lord, explain, my lord, what are we praying? My lord, may I just pray for one thing, my lord? My lord, kindly, my lord, kindly, my lord, kindly, my lord. My lord. But as early as possible, my lord. My lord, no, Lord, Lordship, as your Lordship pleases. Great, Lordship. My lord. As your Lordship pleases. Yes, Lordship.
I feel this is again is an application for expeditious disposal. But Manoj, I at this stage prefer to withdraw the application. Not because what I heard, Manoj, because an application for return of the plate has been filed by the plaintiff after this application was filed. Strategy. Huh? Liberty, brother, liberty to oblige. Grateful.
stick to it, my lord. Okay. My lord, I am for the petition, my lord. The last occasion this matter was, my lord, heard by your lordship, when his lordship was of the opinion, my lord, an application, my lord, an order, my lord, allowing an application under Order 6, Rule 17 of the plaintiff to amend the plain, my lord, that has been allowed ex parte. Now, my lord, I have, my lord, assailed that order before your lordship. On the ground, my lord, that absolutely non-speaking order, it's a 3-line order. Your lordship will, my lord, find it at the last page of the certified copy. But your lordship was of the view, my lord, whether this revision, my lord, since, my lord, the order was passed ex parte, my lord, in the learned trial court, my lord, whether any application is pending, my lord, for setting aside the, my lord, the suit from the ex parte board, whether that is pending. And, my lord, whether, my lord, if I am, my lord, at all allowed, my lord, to challenge this order before your lordship at this stage, my lord, since, my lord,
This so far as suit was proceeding ex parte.
yes, on the last occasion, on the last day, it ran ex parte. On the day, my lord, the order was passed, it ran ex parte.
So, if you have not applied for vacating the matter from the ex parte, removal from the ex parte board, how can I? Nothing remains in the matter. If you challenge this order, you are not entitled to be heard.
My lord, I'll just
Show me the amendment was bad. Simply, otherwise I will not interfere.
Yes, my lord. Kindly, my lord. That point, my lord, and
Non-speaking order does not matter. What he will write, you have not appeared.
my lord, kindly, my lord, takes up, my lord, the amendment application first, my lord. Then it starts at, my lord, page 16.
No, you go and apply before this
My lord,
for
kindly,
removal from
my
the ex parte
my lord,
board. Otherwise, I will not interfere.
lord, kindly, my lord, gives me, my lord, 2 minutes of, my lord.
You go and apply. I will grant you that leave. Apply for removal from the ex parte board thereafter.
My lord, kindly, my lord, gives me 2
No,
minutes.
I will not
My lord,
permit
only
you to
one
challenge.
point, my lord. My lord, only one point, my lord. My lord, my lord, but for my lord, my satisfaction, my lord, only takes up, my lord, only 1 point.
Yes.
Dar. My lord, kindly, my lord, takes up.
I will record. This is only clarificatory. Matter will you will be facing serious difficulties.
My lord, only
If
one
you
thing, my
ask
lord.
this court to go into the issue whether this amendment can be sustained or not, you have no defense today.
My lord, may I, my lord, say only one thing?
You
My
go
lord?
before the court.
In, my lord, when my lord, ex parte decrees passed, my lord, the defendant has, my lord, 2 options.
Yes.
One, my lord, to file an appeal. The another, my lord, is to apply for an application under, my lord,
I've
order
seen the schedule.
Order 9, Rule 13.
Without your objection, I will consider this is only clarificatory.
No,
you
my
go
lord.
and apply before
My
the
lord,
learned trial court.
My lord,
Today
my
it
lord,
is in the ex parte board.
my lord, schedule, my lord,
Ask for recalling.
my lord, so far as 1, 2, 3, absolutely, my lord, formal in nature. After that, my lord, 4 onwards. My lord, 4, 5, 6, my lord, absolutely new, my lord, facts are being, my lord, incorporated.
Why will I hear you? Today, there is a running in the ex parte board. I'll not stay, not do nothing.
My lord, kindly consider only one aspect.
I'll
my
grant
lord.
you leave. Go.
My lord, only one aspect. My lord, after that, my lord, I'll go. My lord, wherever your lordship says, my
No,
lord, I'll go.
unnecessarily I will not grant
But
this.
only, my lord, one aspect.
Yes.
My lord. My lord, when a decrease passed, my lord, ex parte, the plaintiff has, my lord, 2 options before him, my lord. One, to, my lord, file an application under Order 9, Rule 32, set aside, my lord, that ex parte decree. Another is, my lord, to directly challenge that order, my lord, by filing an appeal.
Runs a serious risk. Today, there is no objection on your part. You go before the trial court, seek for vacating of the ex parte board and recall this order. If you want to.
But certainly I want to, my lord, certainly, my lord.
Apply before that, then I'll record your
Then,
submission.
my lord, kindly also, my lord, gives me a leave, my lord, to file an objection, my lord, against this. Otherwise, my lord,
not grant you any leave.
Otherwise, my lord,
Where there is nothing.
my lord, otherwise, my lord,
I will permit you to withdraw this application to apply only.
Otherwise, my lord, the difficulty I'll run is, my lord, even if the ex parte, my lord, the suit is being, my lord, vacated from the ex parte board.
Can come from that order.
My lord, yes, my lord, I'll join, my lord, after
Challenging the order dated, order number 70.
My lord, this will be sustained, my lord, that is the difficulty. My lord, this order, my lord, I cannot touch, my lord, even if the suit is, my lord, removed from the ex parte board.
Did it's you have filed Vokalatnama on the next date?
No, my lord, no.
Yes. Today is.
My lord, I was, my lord, directed to file my show cause. That I did not. Kindly, my lord,
Come to the case record is put up. PO on the strength of put up petition filed by defendant. Defendant files Vokalatnama through learned advocate. Let it be kept on record. It is later. That page. Yes.
Yes. The case record is put up today before the learned PO on the strength of the put up petition. Defendant files fresh Vokalatnama. Fresh.
Challenging the order number 70.
Well, the only difficulty is, well, this order I cannot touch. Even if, my lord, the application is, the
Civil
suit
Judge
is, my lord,
Division, Holdia, Purbo Midnapur, in TS number 103 of 2020, allowing the application filed under Order 6, Rule 17, allowing the application of the plaint filed under Order 6, Rule 17 of the Code of Civil Procedure. The instant revision application has been filed. It appears that the suit was proceeding ex parte as against the defendant. Understand what will you do with this?
My lord.
Your suit is running ex parte and I will hear you here. Is it possible?
My lord, grateful, my lord.
Go before the court, apply for removal from the ex parte board, apply for recall of the order. The court will hear.
Grateful.
55, my lord, I'm for the petition, my lord. There was a caveat I have served him.
One more line. Dismissal of the aforesaid revisional application shall not stand in the way of the petitioner applying before the learned trial court if the petitioner is otherwise entitled to in-law.
Great.
I'm not, that's why I've said. No, otherwise difficulties, his right may be forfeited. His right has been forfeited. এই লাইনটা দিয়ে দাও in law. Otherwise this becomes advisory, correct?
Great.
But item 54, I am for the petitioner, my lord. The caveat was there, I have served him, my lord. I have come up against an order rejecting my 7172 petition, my lord, for delay. There was a
Why on
delay
the
of
last occasion, what happened? Who
No,
sought
this-
adjournment?
This was taken first time, my lord. No order was passed for dismiss for default, my lord. On the day, no order was passed. I came back and I said.
So that is why it was not taken up. Yes, it was dismissed. So you continue. You want to file a restoration application?
This was not dismissed.
Continue.
And I have come up.
What are you challenging?
And I have come against an order rejecting my 7172, my lord, on 18th May 2022. Thereafter, as my 7172 was rejected, the opposite party number 2 filed an application.
On the ground, 7172
For delay. I have not
Delay
filed
in
it.
what?
I have not filed it within 30 days. A statutory period is 30 days. I have not filed it. There was a delay of 19 days. I filed an application for section 5 also. I filed an application for section 5 along with my 7172 petition. All three were rejected, not considered. Now, my lord,
Not considered.
Yes, my lord, not considered. The delay part was not even considered as it has been in the order.
Who is competent to condone the delay? Who is competent to condone that delay? 7-1 delay.
Yes, my lord.
There are two aspects.
Yes.
Under 7-1, what you do? 7-1 has 3 parts.
Yes, my lord.
What is under the 7-1 first part? Or within 30 days from, if I wrong,
Yes, my lord. From entering appearance.
Not entering appearance, within the 30 days from the date of service of summons, you will deposit with the learned court A, the current due, B, the outstanding admitted due along with interest, perhaps, Mr. Banerjee, along with interest, specified date, admitted due. Now you may say that nothing is admitted.
It
Then
was
nothing
against
is
the-
admitted is not possible. Something may be admitted and something there may be a dispute.
Yes, my lord.
There may be also another issue of landlord tenancy relationship that might also come in 7.2.
Yes.
Now, the 7.2 says that in case the court determines relationship and the amount of default, the court will give you opportunity to make payment within a particular time, and that can be extended once subject to the outer time limit.
Yes, my lord.
Correct? Here your default is in the first stage.
Yes.
So it becomes a non-starter.
Only one thing, why the delay has occurred?
No, that will not go into. How can I go into that?
His client, that was not
That is bad, sir. This ought not to have done, sir. Then
I do not
this
know
will
that.
only invite such serious costs.
I do not know, my this is a pro bono case, and only one thing, the husband of the petition has already died. The case was against the husband. In 2014, the husband has died. 7172 was rejected in 2022. There was an evidence leading that. I do not know about the challenge, my lord.
What is the rental, Mr. Banerjee? And how much is the due? I'll put it that cost.
I will kindly not do that.
No.
I have stated in paragraph
no,
23, my
no.
lord, I do not know.
No.
But I have also
Mr.
come up
Banerjee, how much is the due? That will be the cost.
But I have also come up against an order dated 4th May 2023. That may be considered. But I have come up against two orders, my lord.
First of all, let me dismiss this application with the cost.
This is a pro bono case, my lord.
Whatever, sir.
Kindly not impose cost upon the lady who is 10 pass. She is a 10 pass lady. The husband of the petition has already died.
360 rupees.
Rate of rent per month, but period is not long paid.
Calculate. 25,000 rupees cost.
She is a 10 pass lady.
I think that should be enough.
Her husband is already expired in
Challenging.
2014. But I have challenged
দাও সার্টিফাইড কপিটা দাও, এটা কপি অফ দি, এটা অরিজিনালটা ফেরত দিয়ে দেবে।
Liberty be given to at least file a
Let a copy of the certified copy of the order dated 5th September 2024 in CO 1941 of 2022 within brackets Srimati Shobi Mukherjee versus Sri Pintu Das be retained with the file. একটা কপি করে ফেরত দিয়ে দিও। এখন
liberty
নয়, পরের দিন ফেরত দিয়ে দিও যখন আপলোড হবে।
only one play liberty to file an against the revision application against the order dated 4th May 2023.
Once you have suppressed this, the other is gone, and you want me to record that is only consequential. Is a consequential order.
Consequential.
In the trial court, procedurally.
Yes.
I will not go there that far. Once this is dismissed, matter ends. Otherwise, there will be no end to the court trying to justify its orders.
No, my lord.
Last minute suggestion, Lord, matter has been made clearly. Argument complete on my part, then during argument of the defendant, the lawyer filed an adjournment petition that I'll argue on the next day. On the next day came up with this that we have filed another revision application.
This was completely suppressed, this order.
5,000 rupees cost.
Made CAB. Read the order.
Is that order? Finish it off.
No, no, ঠিক আছে, এই তো order generation.
You will only appear for the
I do not.
client. Tomorrow, if the client disowns you,
If
I did not engage. You filed a Wakalatnama. You filed Wakalatnama, it is along with
I
the
am the
petition.
advocate on record.
No, no, it is along with the petition. I understand. Similarly, in the other matter, it is along with the petition. How can he deny? Call the next matter.
This matter, my lord. My lord will find, my lord, it is an application for expedition hearing on the last occasion. Lordship was kind enough to direct, my lord, whether any interim application is pending before the lower court or not. My lord, an application is pending, my lord, before the lower court, my lord, and they are not paying the rent, my lord. A application to the judge, an application is pending before the lower court, my lord, and my lord will consider.
Why did you not disclose it earlier?
It is in terms of lordship direction, my lord. I came to know on last occasion, my lord.
Why did you not inquire? You're an advocate. You
My lord,
duty
my
bound to
lord, my
inquire.
lord. I was on record.
Yes. What is this going on, sir? You are filing applications.
Could have been done.
Yes.
Query that day, I remember whether there is.
Sir, you tell me, an interlocutory application is, can I direct? What will the court say? That this was not considered by the court.
So, my lord, there is only this application which
I'll
is now
dispose of,
pending.
I'll direct you
Direct them to dispose of this.
Pending since when? 2021. Although the initial revision
I beg to appear for the petition. My lord, it was in respect of that matter, your lordship had asked me to check the plaint of both these suits. Section 10 application, that stood allowed. Now, my point was, once that court had rejected that application, subsequent application becomes barred by the principles of res judicata. This court had no occasion to allow that application. Once Section 10 application was rejected by the self-same court. Now, my lord, that's the first point that I'm on, your lordship. My lord, that cannot be, because that the subsequent order that cannot sustain, it is absolutely not maintainable. That was my first point. And if that succeeds, my lord, I choose not to enter the second
Res
point.
judicata.
Because it cannot be, it's once rejected. Self-same cause of action.
Sir, please try and understand. Res judicata is a different point altogether. It may be an abuse of process of court.
It can be an abuse of process. All the points agitated, my lord, it's taken as the same.
Where?
Kindly sees.
Both the plaints have you read?
My lord, first kindly comes to page number
No,
30.
both the plaints. What is your plaint?
My lord,
What is your plaint?
my thing, madam, I pray before your lordship is that.
Plaint. What is your plaint? Prayer in the plaint.
Oh, my prayer, I am the plaintiff, in the title suit, I am the plaintiff. A section 10 application was filed, if that is for declaration, suit for declaration and injunction. Now, my lord, what,
Against this defendant.
yes,
Only parties are common.
yes, parties are common. Parties are common. In fact, my lord, I shall appraise your lordship of the fact that the suit
Second
property.
suit is filed by?
Second suit is also filed with the same plaintiffs. Measurement of land is different. Schedule property, Schedule A property remains the same with owing to the measurement of land that is different. Now, my lord, kindly comes to the impugned order that is there. My lord, the certified copy is annexed.
You are plaintiff in both the suits?
Yes.
First suit you filed against this?
Excellent.
Same defendant. Tell me, answer me.
Gopal, during the pendency, Noni Gopal Bakondi, my lord, kindly comes to page number 51.
First suit you filed against the same defendant.
No, I filed it, my predecessor filed it. The defendants, owing to the, my lord, only the schedule property, the measurement of land is different. Measurement of land is different. Only I'm on a very simple point, my lord. Once a section 10 application.
That is not so simple as you are trying to make. There are other difficulties galore. Where is your
On the
leave
last
under
occasion-
order to rule 2?
No,
Where is your leave under order to rule 2? Where is your leave under order to rule 2 reserving a right to file a further plaint on the self-same cause of
only
action?
difficulty is I could not get hold of that previous plaint. A certified copy has to be taken out because the learned advocate is conducting that matter. I could not get hold of that suit.
Next month the list.
No, the difficulty is that my only thing I'm on is, my lord, the learned advocate is not there. He has gone to Vellore for some.
You appoint someone else, get it. That cannot be a ground for
No,
stay.
Only thing, my lord, can listen. BS me for a moment, my lord.
Please understand two things. You file a suit in respect
Well, I'm
of-
absolutely
Listen to me,
completely in
listen.
dark with regard to that title suit.
Listen to me. You file a suit. Your predecessor filed a suit means you filed a suit.
Yes.
Let's not go into that aspect whether your predecessor suit you are bound or not. So your predecessor.
Lordship kindly takes up the impugned order for a
Listen
moment.
to me. I've seen section then or stays there.
Yes.
Your predecessor filed a suit.
Act a second.
For declaration and injunction in respect of the self-same suit property. You have subsequently filed a suit in respect of the self-same suit property. The properties are different. The measurement is different.
On the last occasion, what your
suit property is the same.
The dark number remains the same.
Now come to order to rule 2 of the Code of Civil Procedure. To me,
I am
that
completely
without obtaining that leave, you can file a fresh suit in respect of the self-same cause of action or the part of the. So whatever you have left out is gone. Why a person? Why this provision is there? Section 10 also same apply on a different footing though, because a person will not be vexed twice for the same cause of action.
I'm completely dark with regard to that.
So bring it. You bring it. I'm giving you opportunity. I'm not dismissing your matter.
The next monthly list, my lord.
Yes, next monthly list. Group A. Since an accommodation has been sought for
My lord, kindly BS me with for a moment, my lord.
on the
Because
since
I
an
I
accommodation has
could
been
not
sought
get
for
hold
on
of
behalf
that plaint.
On behalf of the, you have to bring it. Otherwise, I'll adjourn it for 2 weeks, 2 months. Make up your mind when
My
to
lord, whether my lord, it could be for not this week, my lord. I just
on behalf of the plaintiff petitioner, on the ground that the petitioner is unable to has not been able to obtain certified copy of the plaint filed in TS number
901 of 2000.
901 of 2000 pending before the court of the learned
ব্যারাকপুর এটা হচ্ছে এতে এডিজে ফার্স্ট ট্র্যাক কোর্ট না এডিজে না সরি সিভিল জাজ জুনিয়র ডিভিশন এটা লেখাও নেই ঠিকঠাক
901 of 2000
2000 yes that has been stayed by an order of status quo but that came up before a second appeal. I'm sorry, my lord, I stand corrected. It is before this honorable court. That order has been subsequently challenged by way of a second appeal. It is pending before the honorable high court. The order of status quo is there. And it was solely on that ground the section 10 application stood allowed. Kindly, my lord, takes up.
where is 9010
90
901 of 2000
yes 901 of 2000 yes
901 of 2000 which court pending before
it's presently before this honorable court by way of a second appeal.
Acha, very well.
That has been adjudicated on merits. Well, subsequently it went up for a appeal and presently it's pending before this honorable court.
কি বললাম plaintiff suit number এত the cause which is pending presently in SCT number 14 of 2019 before this honorable court. Full stop. Get it from the high court. Having regard thereto, let this matter stand adjourned and appear under the heading new motion 1 in the monthly list of March. Will take some time.
February, my lord, kindly.
You won't get it in
I'll get it. It's available with the lawyer itself since he is not there.
I'm placing it new motion 1, so it will be 5 or 6 item numbers 5 or
But
6.
make it in the month of March. I'll be getting it because the advocate. I'll be
Get it for 2 weeks. Yes,
But
for
I'll
the next
get it
matter.
for the advocate itself, my lord.
Yes,
I'll
you
get it.
and come back on the next date.
But the March will be too late, my lord. Kindly.
Why?
If February, my lord, kindly.
Nothing will happen.
Kindly takes it up, my lord.
No,
Because the
no.
suit is remaining.
I'm group 1.
Order 26 rule 9 application is pending and
Call the
interlocutory
next matter.
application
Call
is
the
pending.
next matter.
Kindly consider, my lord.
You ought to have brought it today.
My lord,
Yes.
the advocate is not there. He is gone for some medical. My lord, kindly
Will come up on the next date. Yes, dakun. Come back. Group 1 it is there. Item number 3 or 4 it will
March
appear.
kindly considers, my
It
lord.
will appear item number 3 or 4. I've said group 1. What are you saying, sir?
Oh, I'm asking only if it could.
Then I'll place it in the last group in February. Choice is yours. I'll place it ordinarily in February. It is appearing in group 1, item numbers 3 or 4. You are not happy, sir. Maximum it will be item numbers 3 or 4 in March. Ki ek number ashbe. Maybe it will be item number 1. Because first, if any matters are there prior to you, those matters will be there. This matter has been filed when?
Long back.
So, item number 1 to 5 maximum. Call the next matter.
Was filed in the month of April 2023.
Then, yes. Who's appearing in this matter? Item number 1095. আগের দিনও ছিল না তো? Very well. None appears in support of the aforesaid divisional application. No. কয়টা টাকা আরেকটা আছে, দুটো আছে। Yes, sir.
Lordship, last occasion, Lordship is directed to take instruction from my client. My client agreeable to pay the rent from the date of purchase.
I'll come at 2. Very well. He's agreeable to pay. At least better sense have prevailed now.
If
Sir, you have to understand the situation, sir.
I will agree.
Yes, that is why I said.
And only thing that
I'll come back. I have to pass an order. It's now 1:15. I'll come at 2. Mr. Ghosh, be there.
from December 2019 to January 2025, 62 months, 350 per month, to 21,700. If he agree, my client ready to pay the cash here and now.
No cash. Cash transactions are no longer permitted.
No, but up to 50,000 is permissible loss.
In court proceedings, why will you pay cash? Pay by check. He will accept by check.
Yes,
Order
yes.
of court. If you default, I will see to that.
No loss, I am agree.
Yes.
Yes,
What was the order?
Lordship, local inspection application was rejected. My client filed a suit for declaration that I am the bona fide tenant without due process of law cannot be evicted. An injunction order was passed to that extent. Thereafter, my client filed an application for repairing of the certain portion and also filed a local inspection.
Where is your application for local inspection?
Yes, Lordship. Page 29.
What are the points you had sought for? Page 29 is the application.
Yes, my
Yes, 30.
scheduled point, Lordship.
Yes, that is the relevant point.
31, Lordship.
Yes, how much is the amount? Rent?
Rent 20 from December to 2019, because November 2019 they are showing purchase and later.
And you undertook to pay month by month?
Yes. Lordship, only one thing, Lordship. Lordship, two things. Two dependent or purchase.
Repair I cannot grant now.
No. I cannot ask a repair. Only local inspection now. Lordship, two things. That dependent on 2 and 3 purchase jointly purchase that property. That rent should be divided to because of no relation between dependent number 2 and 3. And
You deposit with the court below.
yes,
I'll permit you to withdraw from the court. No, not civil deposit. Directly with the court.
yes,
Directly, I provide for that. You actually, because I will not go into this issue.
yes.
Not necessary for this court to decide. You convince the court and take out the amount.
Only another thing, Lordship, kindly.
Again, another
No. Already rent control already deposited.
That
Kindly
yes,
permitted
liberty,
to.
yes. I'll grant you that liberty to withdraw. Anything else?
No.
Challenging the order dated 1st March 2024, passed liberty to withdraw the money deposited by the petitioner with the rent controller at the risk and cost of the petitioner. At your risk and cost. At your risk and cost, you will withdraw. Yes, yes. Yeah, because he is withdrawing, it has to be at his risk and cost. I am not asking him to withdraw. Next. Yes, sir.
I am appearing for the Commissioner of Law. My application for local inspection has been rejected.
Yes, sir.
So I have.
Why, sir?
Well, in my opinion, on some irrelevant grounds.
Why did you ask for local inspection, sir?
In the suit plot, Lord, that is VT, and I have.
So I could not hear you. Sorry, sir. Please.
I have shop, Lord, there.
You have a shop. Yes.
And different electronic materials are sold and other materials are sold. And the defendants are claiming that they are in possession. So to ascertain the possession and present condition of the suit property, my lord, we made the application for local inspection, my lord. So Lordship kindly sees what are the points, my lord. That is, page 43, my lord, application, my lord. On page 44, my lord, para 4, the main point, my lord, why the application should be allowed, or what the petitioner intends to bring before the learned court below.
The learned court says that there is no allegation that they are trying to interfere with the position.
Yes, my lord.
Place this order.
My lord, that is from the very beginning. I shall read, my lord. Today's
The suit has been filed by the plaintiff. Suit has been filed. After ABCDEF.
Suit has been filed by the plaintiff for declaration and permanent injunction, restraining the defendant from disturbing the peaceful possession of the plaintiff over the suit property. The prayer for local inspection is on the line of noting the local features of the property and to note if any construction has been done on the said property. The application does not mention the reasons why the plaintiff requires permission and what is the objective behind the same. There has been no allegation of encroachment or construction by the defendants over the suit property. The suit is for declaration and no prayer for recovery of possession or mandatory injunction has been made. Hence, the point to note whether any construction has been made on procedural property is outside the pleadings of the plaintiff.
Absolutely. Absolutely. Why will the court note down whether any construction has been made?
No. In my application, no such prayer has.
Yes, you have made. To draw a sketch map of B schedule to note the condition of the property. Note if any construction of B schedule property has been made.
That is my construction. Whether I have shop room or not defendant, not.
Why will the court go and inquire in your position? It is for you to establish. It is for you to establish.
No, Lord,
what is the plaint for?
Plaint for declaration and permanent injunction.
Where is the plaint?
Plaint, my lord, that is at page number certified copy, my lord, page number 12, my lord.
That too certified copy?
Yes, my lord.
You don't have a copy of the plaint with you?
No, my lord, there is no problem, my lord. That is also.
Yes. Apprehension is there that you will be dispossessed. Why will is necessary to inspect your property?
To show before the learned court that my showroom is there and that a
Where is
business
the statement made in your plane that you have a shop room?
that is in the schedule, my lord.
Where is the statement made in the plane that you have a shop room?
That is page number that starts from paragraph 4, that after demise of the Pulok Satra, the plaintiffs are in jointly.
Where is
absolute
your
joint-
case that this shop room is being
Yes,
will be
I am
demolished?
correct. They possess without any disturbance from any corner. Plaintiff number 1 also running his father's business under the name and style Satra Furniture and Electronics. So this is the shop room, my lord. I just
Sir, you have a shop room. Your apprehension is they'll try to dispossess you. Why is it necessary for you to take a local inspection for purpose of assessing the local features of your shop room? Or why will the court do that?
No, that is to bring before the learned court that I am in possession of the
For
property
that purpose is not necessary, sir.
and that I run a business there.
You run a business, there are other documents to show. For that, no
I
local
have
inspection is
annexed those
necessary.
documents, Lord. I have annexed those documents.
Very well, not necessary for that purpose.
No, Lord, this is necessary. Otherwise, Lord, they are ignoring that. They are saying that they are in possession. That will be harm.
You have filed a suit.
No, that is why the suit has been filed, my lord.
What is the local inspection to carry out construction features inside your property? Why?
No construction. My lord.
Yes, sir.
No, my lord. That is wrong. The wrong understanding of the
And where is your application? Order
Application
39,
page
Rule 7?
Page 43, my lord.
Yes. What is the schedule?
The schedule, my lord, page 45, my lord. Schedule A.
Come to see of that schedule. It is a wrong understanding of the judge. Let us understand whether it is a wrong understanding of the judge or wrong understanding of the petitioner that he has made this prayer.
No, this construction, that is.
So the schedule according.
Construction, not of the defendant, my lord.
So therefore, why do you want the court to see that? Where is your allegation? He's trying to.
Oh, that I am in possession and I am
No,
running business.
not for that purpose. Anything
No,
else? Anything else?
No, my lord. That is to show, my lord. Otherwise, my lord, they are claiming that they are in possession. That is.
Where is the written objection?
Confirming my position.
Where is the written objection that they are claiming they are in position? Sir, you have to establish whether you are in position or not.
That is, but this will not support my case, blood. That is why I shall.
I don't know what is your intent behind all this.
No, there is very simple intention that I am running. We
Sir,
are
all prayers are not as innocuous as they are.
Yes, my lord.
Sir, I'm not speaking about you, your client, sir.
No, that is my lord, that
Yes, sir. The present revisional application has been filed inter
matter, I appear for the petitioner, my lord, who is the respondent wife, my lord, in a suit under section 27 of Special Marriage Act, my lord, for praying for decree of divorce against the wife. Now, my lord, I am here before your lordship challenging the propriety of an order, my lord, by which I have been, my lord, my written statement has not been accepted on the grounds of delay. My written statement, my lord, may I directly take your lordships to the, my lord, order?
Who has filed the suit for divorce?
My lord, the husband, who is the opposite party.
When was the suit filed?
My lord, the suit that I entered appearance, my lord, 10th of March 2022. My lord, yes. It is at page 20. Your lordship will file, my lord, the affidavit.
So when did you file? When was your WS filed with the records? Acceptance will come later.
Yes, my lord. I had, my lord, way back, my lord, written statement and application for condemnation of plea was filed on 18th of October 2023. I entered appearance, my lord, yes, quite a lot of time. I entered appearance on, my lord, 12th of May 2022. So, my lord, a little less than 1 year, but there is a reason, cogent
Did you
reason.
make any prayer for restitution of conjugal rights?
No, my lord, but there was a prayer for reconciliation, based on which, my lord, I'll tell your lordship what happened. My lord, I entered appearance, my lord, I sought time once or twice, my lord, for filing written statement that was granted to me. On the concerned date, my lord, when I was supposed to file the written statement, my lord, I saw, my lord, the wife saw
What do you do?
my lord,
What do you do?
unemployed. I could I'll take 1 minute, my lord.
You're unemployed.
I'll just take 1 minute. My lord, it's written, my lord, service, my lord. I specifically do not have any instruction on what kind of service, my lord, but it's written, my lord, service.
He can serve from the lowest grade to the highest grade.
My lord,
What is she doing?
Private company insurance.
my lord, I'm told that she works in a private insurance company, my lord. That is what she does. Bajaj Alliance.
Yes.
And
What
not
do
a
you
very,
do?
my lord,
What do you
hi-fi.
do?
Instruction, I have a job.
Job, what job? I don't know.
You have any children?
One child, one female.
Child resides with?
Father now. No, my lord, with me. With me.
How old is it? I'll hear you, sir.
Lord,
Please. I'm trying to ascertain the facts, so collate them. Yes, how old is the child? Girl child or the it's a
Girl
boy
child, my
child?
lord, girl child, Medha, little over 6 years
Don't
old.
name the child.
I'm very
Appear for the petition on read by Mr. Bank.
Yes.
It's all about the partition. From the days of Muhammad, it is going on. So naturally, my lord, there are four brothers. In the lifetime, my lord, father constructed a house. Very well, no problem, certain. All the two, they are residing there. Now, one brother, my lord, actually what he did, he gifted the property in favor of another brother. The other brother filed a suit for partition, not my clients. In the suit for partitions, my lord, ultimately a preliminary degree was passed. 50%. So naturally, when the brother who gifted that property, he certainly prefer an appeal. The division bench asked him, how is it? How we can do that? No, I will not allow you to. But allowed to argued, failed, and appeal is dismissed. Against that, they went up to Supreme Court. Pattopat be there. So this is the situation. Now, during the course of hearing in the appeal court, my lord, and high court, there's a dispute. So naturally, court says very well about the share. I am appointing casually. I am appointing special officers. So joint partition, I am appointing joint partition commissioners. They will do that. The two report because according to the extent of share will change. If it is change at all. And
I could not follow. Second part. How the commissioner of partition will decide on the shares? No, I'm just asking you.
No. Judge says.
Yes, okay. Achha.
He cannot decide the share.
Yes.
Because the plea was taken that, well, I've got some share. At that time.
I see. So who had gifted?
Yes, he claimed.
Very well.
So court said very well, since the matter is pending, I'm just appointing to both purpose. If your portion is
Where is that order?
Which one, my lord?
The appointment for commissioner of partition. That's by the division bench.
The first appeal, my lord, naturally. Page 55. 42. ভালো করে দেখে বল। 42 order. দাঁড়া হরবর করলে হবে না দাঁড়া 41 42 আচ্ছা এই তো এটা কি না
Oh, I see. So two plans were directed to be prepared.
Nothing more, nothing less. Subject to final. Because if it is ultimately found, the person who gifted the property, because at that time it was all disposed of, gifted the property, he has got no share, then naturally. Now, when this matter was finally disposed of, kindly take trouble to come. Volume 2 thing. Volume 2 দিয়েছিস তো ওখানে আছে তো? Kindly come to volume 2. হবে না ওই ডিভিশন বেঞ্চ জজমেন্ট 142 ভলিউম 2 আমায় দিয়েছিস আচ্ছা তা হবে 162 140 kindly come to 142 volume 2.
Yes.
The very lengthy judgment, everything was considered. Well, at 142, judgment starts. Now, he was also represented by his counsel. Then ultimately, Justice Somen Sen, sitting Justice Siddhartha Raichodhuri, as he also then was, dismissed the appeal, their appeal. But with an observation, which is very relevant to me. Kindly come to page 162, my lord, which is very relevant. Entire thing was considered, dealt with in details, judgment delivered, ultimately appeal dismissed. Against that, they went to Supreme Court. 162 kindly come. It starts from in view, the last paragraph, in view of the fact that we have dismissed the appeal, the original report filed by the Joint Commission of Partition It is sent down to the first court of civil judge, civil division at Alipur, in connection with the title suit number such and such. After returning a photostat copy of the same, along with NCR within 2 weeks or such. Date for expending the expediting the final degree proceeding. The learned trial judge is requested to conclude the final degree proceeding for expedient possible and without continuing. Then the learned trial judge in the said proceeding may take into consideration Kalisi minor. Entirely for obvious reasons, because one judge says this under what situation that was done, entire situation and scenario is changed. So naturally, concerning judge, learned judges, they thought that well, that type of remarks and direction to be passed. If the learned trial judge in the said proceeding may take into consideration the said report. However, the access of the said report is left to the discretion of the learned trial judge. The parties shall be heard on the said report if you accept as answer. Now, what the learned judge did, very unfortunate. We raised the objections. It is not the way to let the fresh partition commissioners. It should be because the situation which was prevailing at the time when the order was passed is now totally changed. For this reasons,
You were conscious of the order passed by the division bench of Justice Mukherjee.
Huh?
You were conscious of the order passed by the division bench of Justice Mukherjee.
Yes.
You permitted the order to continue.
Certainly, my lord, I'll have to do that because everything subject to appeal was pending at that time. So that's why judge, honorable judges made this remark, may take him. So if
No. Mr. Banerjee, why this may? May is, and my correct me.
Yes, no.
In a partition suit, first is the shares are decided. In your case, the shares remain undecided because an appeal was pending. Decided means it was decided,
Sub
but
judice.
continuation. Yes,
Sub
sub judice. It was to that extent, sub
Yes.
judice.
Mm.
Therefore, the division bench considered it fit to prepare two partition. Correct?
Yes.
That was done. Now the appeal court ultimately in the year 2022
dismissed the appeal.
Dismissed the appeal.
Now, once it is dismissed, what will the effect?
So one of the partition plan which was prepared by taking note of the share of that party,
all parties
could no longer be accepted. But the partition plan which took note of the situation as was prevailing without the appeal was placed before the learned court for acceptance. That is what the my understanding.
No problem.
That is what the learned court this is honorable court, division bench of the honorable court may have directed. Now let us come to the order. Let's find
Now,
out
what I want, my lord.
Yes.
I again, at the cost of reason, emphasize what was playing in the mind of the honorable division bench. Look, all these things were done during the pendency of the appeal. Now, when we dismiss the appeal, whatever interlocutory order was passed, that is to some extent gone. But still, the honorable judge says, and we took the exception of that. Honorable judges may, that is why, otherwise there is no commission. Commission report is there, so accept it. Carry on. Court never says like this.
You cannot. The commission report of the commission of partition under order 20 rule 12 initially the preliminary decree is passed. Now this final decree is passed under order 20 rule 18 perhaps. I have to check out once again. So
No,
that
you're
is
right.
passed. But prior thereto, the report of the commissioner of partition has to be accepted. You have a right to challenge the report.
We have objected to the report.
Correct. So you
that
have
has
a
not been
right-
taken into consideration.
So let us find, yes. From
Yes.
that you show me. From that you show me. Yes, I will consider from that.
See, the order is that page. A page you have the order he has. May I place it, my lord? Today's fixed
Yes,
for-
your submissions are recorded. Report of, yes, the third paragraph, fourth
But
paragraph.
kindly see nothing, no consideration. High Court দিয়েছে তারপর বলার কি আছে? It's like that.
You may be right, but let us go through that.
Yes.
Let us go through that.
And very vital aspect has not been taken. As you have learned since your joining, my lord, normally in a partition, always amongst the owner and brothers, sisters, what I want, my lord, is the basic principle. My lord also knows, my lord did several cases like this.
Sir, my learning process, sir. Every day I get to learn so many things, sir.
এই তো নয় মুশকিল বলছি দাঁড়া না ব্যস্ত হয়ে যাচ্ছ। Now, my lord, kindly see The basic thing is whoever in positions to be maintained. But if the valuation, suppose there's a partition between X and Y, X property is better than Y, then Y will be compensated by royalty money. So position, since the time of my father, both father are residing there, he is also residing there, and respective flats totally change. That you can't do. That is basic in the basic principle.
That is more acceptable on
That is
this
the
aspect.
that is basic
Certainly, yes.
principle.
Yes.
Basic principle. My lord knows that. Kindly see, during the course of hearing, learned advocate for the defendant number 2 raised objection against the final report by the learned joint partition commissioner by stating several counts as follows. Report of the survey cum civil engineer annexed with the final report can be viable in the practice of this case. If the final degree is based on the basis of the said report of the survey cum civil engineer, it would be non-executable. The learned joint commissioner report is prepared by discriminations in the allotment of the parties as learned joint partition commission did not follow the terms of the preliminary degree and intentionally overlooked the contention of the petitioner that since 1982, the defendant number 1, Jaswant Chapadia, has been possessing the entire first floor, and his wife and himself has been suffering from various ailments. But the learned joint partition commissioner.
This first floor was allotted to whom? Has been proposed to be allotted to whom?
But that is now it is allotted to plenty. It is totally cannot be done. We are actually dependent. Now we are going that. Problem is otherwise. It could have been sorted out. Problem is
this is the only dispute.
No, what I'm on, my lord. 4 stories building, no lift. Everybody is trying, I need that. If everybody needs that first floor, it can't be possible. Let them be lift. All coaster will pay the money because of the lift. There is no problem. But why you are disposing me?
No, sir. Sir, like if you don't have a lift, you don't have a lift. For that, the commissioner of partition will not construct a lift.
It is not the commissioner. It is not the commissioner. It is before your lordship, I'm saying.
That is a different. But the commissioner cannot be called on to construct.
No, you are absolutely correct.
Yes.
That cannot be the law.
Like whatever is there is there.
Is there.
Partition it.
That is why I say whatever is there is there. Then how we can dispose me?
So let me understand this. First floor you are occupying.
Yes.
At present today.
Yes.
Yes, sir. They are occupying first floor. No, please tell me something. Please understand the situation. Please understand. Two things are very important, sir. Your challenge to the shares has been rejected. Finally. And if you have moved before the Supreme Court, I don't know.
Yes, yes.
Rejected.
I am before the Supreme Court and that is pending.
No.
Pending.
Repeated. Someone has moved and matter. You are who? Who are you, sir? You had challenged whose appeal was it? No. Whose appeal was it? Your appeal.
And I have cross objection, he has filed.
So it has been decided. If one matter has been decided by the Honorable Supreme Court, where the Honorable Supreme Court unlikely to change its mind on this. So already, sir, it has been decided. For that, you can't ask this court to wait forever after. Please understand. Partition suit pending for years.
There is no stay.
Let us solve this issue. Let us solve it. Please understand. It will not help you, neither help Mr. Banerjee's client.
Absolutely correct.
He was in occupation of the first floor. He has left to America, different issue.
No, permanently. Your daughter's marriage.
Sir,
Come
please,
back.
sir, please give me 5 minutes, sir.
Yes.
Very well. So it's another place. He is there in occupation of the first floor. Fine. Temporary accommodation in America, it's temporary. Where are you occupying?
One thing that has not been told.
No, you tell me, where are you occupying?
Ground floor and third floor.
First floor has been allotted to whom?
There is no allotment under the partition plan, Your Lordship. And exactly what the order records, the order that's been challenged. It should be decided by the final decree that is passed in the proceedings, which is not being done. The final decree is yet to be passed.
Naturally,
final
decree, there can be more than one preliminary decree.
Right.
But final decree will be one, sir. Final decree will be only after the entire proceedings are concluded. Now, if the first floor has not been allotted, Do you concede that this allotment shall go to them?
We have done that. Your lordship, see the improved order. Kindly see the improved order.
You tell me, sir. You tell me, do you concede that it should go to them? So one of their objection will be taken care of.
Which share you want? So, your lordship, please give me.
Yes, yes. You are Mr.
I'm prepared.
What is your name? Yes, Mr. Chaudhary. Yes, yes.
Now, fine. Let the gift be as yes.
No, assuming, sir, it is valid now. It is decided. Yes, yes, yes.
First floor and second floor is one lot. The partition commissioners have divided first floor, second floor into one lot.
By treating gift deed is valid. Both the plans are by treating gift deed is valid. Please tell me this.
No, no.
Mr. Banerjee, wait.
Oh, sorry. I'm sorry.
Yes. Yes.
There are two plans.
Which plan was
The division bench to be fair.
which plan?
Gift deed is valid. They have their share.
Yes, very well. So speak about that plan only.
So there are two lots prepared now.
Yes, yes. How many parties are there? Two parties.
The plaintiff and now there are two defendants because the gift deed is valid. Gifted to
Two defendants, right?
So two lots.
One third share each. One third share each
Because the 50% share of defendant number 3
has been gifted. So 50-50, fair enough. Fine.
these plans of partition are prepared. We are only concerned.
How many floors in the property? 4 floors. Ground plus 3. Ground is residential.
Semi-residential and the remaining. And the staircase.
Fine. Fair enough.
Your lordship, please.
I'll come to that. Let me understand the facts from you, and thereafter I'll go. It'll be easier. I have got a grip of the matter very well. There are certain proceedings where they have understood. Now I am on the plan. Now there are first floor and third floor, second floor and fourth floor. These are the two lots.
No, ground floor.
And second and third. These are the two lots.
I see.
And it says there is no allotment being made by this plan, allotment to be made by final court order. And when the matter came up before the learned court.
How can it be open, sir?
So your lordship, what happened was when the matter came up, the plaintiff for the party submitted to court, which is recorded in the order, that we are giving you an option to choose between two lots. So if you want the lot with the first.
Mr. Banerjee, choose. Mr. Banerjee, choose the lot. Complete. Partitions would never end, Mr. Banerjee.
So,
Your experience, you have a vast experience.
no,
You
not
are
fast. Only
yes.
52 years, not fast.
No. I 52 years. Mr. Banerjee never ends. Never ends. So choose a lot. Go and sit with Mr. Banerjee. Seek the modifications, come back. I'll allow whatever you want.
Chalo.
I think, Mr. Banerjee, it will be better.
I think so.
Because you see, these way are never ending. One generation goes,
I appreciate my.
the next generation comes in, but the matter will remain pending.
এখন next day এসে বলে বাবুটা উঠো করুন তো ভালো লাগে না।
You go and sit with Mr. Banerjee. Very well. Mr. Banerjee, senior counsel, senior advocate of this court. What are you saying? He's saying in court, go there. The parties would submit that there is a possibility to resolve.
সে বলছে
That is also possible since this is an open
kindly
offer.
record it, my lord, then.
Yes, yes, yes. It's an open offer. It's an open offer. Yes.
His client is also, if I'm not
Yeah,
wrong,
everyone is here.
Let
Yes.
me record it. Let me
Yes.
record it, my lord.
No, no, no. I'll fix it on that date. I'll take it up. I'll stay it. That is not an issue. I'll stay it. But I'll record.
তারপর দেখ ভালো লাগে না।
No, Mr. Banerjee, see, when counsels like you appear, you always keep the court with such wonderful spirit. So the court.
The other day, some gentleman lawyer showed me one কি বলে টিভিতে সেখানে দেখাচ্ছি মানে জাস্ট I told the other side, ইয়ার তুই কি নলকিশোর চৌধুরী কে হোস? কে? That his grandfather engaged me in so many cases.
Yes.
So he says, গরিব ব্রাহ্মণ সন্তান একটু কথা বলতে তাহলে মক্কেল ফি দেবে না। Now they say everyone putting me, আরে দাদা কি বলেছেন স্যার কি বলেছেন? যা বলেছি তো শুনেছি কি আছে? I'm a poor Brahmin. আমার কথা
Yes, call the next matter.
My lord, the Supreme SLP is pending. Kindly record that with this pending.
Sir, let it come back. Let them come back and indicate. I have not disposed of the matter, sir.
Kindly record my submission.
No, not today or not next date, sir. Next date, next.
may leave my lord.
For that, nothing to do with this allotment case. If you succeed, everything will be turned before the final. Yes,
My lord,
everything will be turned around once you succeed there.
Everything will be changed.
Yes, yes. No, not today. Not next date. Come on, the next date.
May leave now.
Yes, yes. Call the next matter. Yes.
For 86, I am for the petitioner, my lord.
Yes.
The matter relates to dissolution of marriage under section 13 of the Hindu Marriage Act. The suit was filed in the year 2017. But till today, my lord, this instant application, which has been in the form of revision application, I am seeking for the expeditious disposal of the suit pending before the third.
You are the husband.
I am the husband.
You are paying maintenance.
Because since the matter has not been finalized, either finalized, now
And you
it has
want the
come.
suit to be disposed of without paying maintenance.
No, no, because
Are you paying
she has,
maintenance or not?
but so far as, yes, sir, Dharana bhai. But there is no any maintenance case filed by the respondent. If there would have been a,
Sir, sir, the present revisional application You need. Goyachol Club. None appears in support of the aforesaid revisional application. Stop. No accommodation has been stopped. In view thereof, the revisional application being CO 1447 of 2024 stands dismissed for default. Next. Yes.
I am for the petition. But this is, my lord, against an order wherein, my lord, the order passed under section 36 of the Special Marriage Act, maintenance, my lord. But earlier, the fact is, the suit for dissolution of marriage was filed by the
One third has been allowed.
My lord, the fact is, earlier an application under section 36 was filed and that was dismissed for default, for non-prosecution. Thereafter, by suppressing of the fact, they filed another application in which, my lord, we failed to appear. And thereafter, order is passed, my lord. A similar application, subsequently, this application was valid. Earlier,
Are you complying with this?
Earlier,
are you complying with this without prejudice to your rights? Are you ready and willing
but
to comply?
I am paying the maintenance in terms of the other proceeding.
125, those are different. You get
8,000, my lord, I am paying.
So 25,000 minus 8,000, how much it comes to?
My lord, it's 17,000.
No, alimony 10,000 per month to herself, 7,000 per month to minor daughter.
Yes.
And litigation cost you pay.
Yes.
17,000 you pay.
But kindly.
Without prejudice, I'll take up your matter. Sir, you cannot say that I have filed a revisional application.
I'm paying, my lord. I'm paying. I meant paying 8,000. 17,000.
Pay.
But at least 15,000 I'll pay.
You comply with this direction, I will take up your matter. If I have sent it back, ultimately,
my lord,
if I send it back, this will be went to the credit. If it cannot no longer be that till such time finally it is decided.
No, my lord. In the meantime, my lord, I'll pay, my lord. But if, my lord,
directed to pay from which date? Date of filing of the application?
With the
from
passing the order, my lord.
Why?
11th.
How can it be? From the date of filing of the application?
My lord,
That is the
earlier
law.
application filed long back, that was dismissed for default. My lord, kindly see.
Today you pay this. I'm recording it. Challenging I'll record that you are willing. That is why.
My lord, let me
No,
take the
no,
instruction, written
I'll
instruction.
dismiss it.
My lord, written instruction, my lord.
Tomorrow.
Tomorrow, my lord.
Yes, call it.
On the daily list, my lord.
It will be there in the list called on. Why daily? Not today. You want it not this week? Take instructions.
Take instruction.
Not this week. লিখতে হবে না কিছু। Call the next matter.
Lordship, I'm on behalf of the
You
petitioner.
have a caveat. And then why making submissions? Yes, sir.
Lordship, this is expeditious hearing of matrimonial suit number 1651 of
Very well. A matrimonial suit. Maintenance he is paying. You are the husband.
Yes.
Yes, you want expeditious disposal. Maintenance he is paying.
I will file the maintenance application. But my lord, may I say this, my lord? My lord, this matter was we filed an application for transfer before Honorable Justice Bhutia. I feel also did. Now, my lord, that transfer application was rejected. Now, my lord, again the transfer application, we filed a review, my lord. There are two applications pending along with the review. We tried out. In fact, that matter is running to justice further, my lord, in the list, my lord. It is coming up on. It is coming on up over every Tuesday. We have mentioned the matter also really. Now, my lord, they are trying for expeditious disposal, my lord.
I'll release the matter. Apply before Justice Bharat.
Lordship, the review application has been filed in the year 2022 and till then it has not been turned up.
My lord, the applications are running in the list, my lord. We have
Since it is submitted by Mr.
I have served lordship, but it has returned to me.
Opore, first line, let a copy of the revisional application be served on the opposite party. Mr. Banerjee, learned advocate, enters appearance on behalf of the opposite party and accepts service. আরেকটা ডাকো 90 করে দাও। এই কতগুলো আছে অরিজিনাল সাইটে দেখো, তাহলে আরেকটু কিছুক্ষণ নেবো। হ্যাঁ, 17টা তো থাকে না তো বেশি।
Lordship, I am for the respondent in item number 90.
90, my lord, 90, my lord, I'm seeking not today in this matter because, my lord, my advocate on record is not available, my lord. He is sick.
What is the challenge, sir? You're for the
Lordship, I'm for the respondent. I'm for the respondent.
You're for the caveator.
No, not for the caveator. I'm for the respondent wife. I am appearing in this matter for the reason because I have also filed one revisional application that is appearing as item number 162. If his prayer is today for time, I am led by Mr. Shubhankar Nag.
Same order challenging to revisional.
Since the subject matter of the instant revisional application being the order dated 20th February 2024, passed by the learned additional district judge 4th court Barasat, not 24 Parganas, in miss case number 03 of 2016, forms subject matter of challenge in CO number such and such, and since the petitioner prays for an accommodation, I am of the view that both the revisional applications should be taken up for consideration together. Full stop. In view thereof, let this matter stand adjourned and taken up for hearing when item number when CO such and such is taken up for consideration. Now the CO, give the CO 16 of 2024.
Great.
সঙ্গে এটাকে। Yes, call the next matter. Yes, 91.
It's not a caveat, but I am happy.
Let him hear then. Yes.
My lord, this is, my lord, my application, my lord, for ex parte ad interim order of injunction, my lord, has been refused by both the courts. Now, my lord, kindly see the ultimately, my lord, initially
It is no longer expired, it is finally hard.
yes, thereafter, my lord, finally disposed of. My lord, the appeal court, my lord, has refused to pass an order of
Suit
injunction.
for?
My lord, suit for, my lord, a declaration, my lord, of declaration that the property allotted to the society, the plaintiff society, my lord, was at a, my lord, particular rate. Now, my lord, it was.
I could not follow.
Kindly comes to the plaintiff. Kindly comes to the plaintiff, which is, my lord, at page.
I've got it 9.
Yes. Kindly see the prayer. It starts from, my lord, at page 21.
No, your allotment did not provide for this rate calculation.
No.
That was there.
Enhancement. We are on the enhancement. We are on the enhancement. We have challenged that part. Now, Miller, initially it's
What
not that-
injunction you want?
No, not to disturb our position.
Without making payment?
No, initial payment we have made. Kindly see, Millard, kindly see the appeal court's order, whether it can.
Are you ready and willing to pay at current rate without?
No, not at the then, Millard, my suit fails.
Why
That
suit
my
fails?
suit fails.
Sir, damages, sir.
No, not at all. I have challenged their Millard notification where they Millard where they said that it has to be Millard on a.
Yes, make out your case, Mr.
Kindly
Bhattacharya. Make out
kindly
your
see
case.
Millard the order Millard of the appellate court. whether this can be sustained on the Millard on the face of the record. Kindly comes to page 4.
Where is your certified copy of the trial court?
It's not there, Millard.
No, sir. Sorry, sir.
Have the
Yes, file it. Yes.
I know, Millard.
Initially I was not insisting, but nowadays I find nobody is handing over the same. Yes.
Kindly see the appeal court's order. Page
No, first come to the trial court's order.
I'm coming to first, Millard. Kindly see the appeal court's order.
Very well, very well.
I'll place them
Yes,
that order also.
yes.
Kindly see page 4. Whether this order can be on the face of it at all, this can be sustained.
Yes.
Kindly see decision with reasons. This
Yes.
is what Millard the learned trial while disposing of the appeal, what the appeal court is peruse the impugned order number such and such passed by
He
the
thought a brilliant order has been passed, so he did not consider it fit to give second reason.
Millard, whether-
That's why I wanted to go through the trial
whether,
court's
whether,
order.
whether this order can be sustained at all.
Let us see the trial court's order.
Very well. Kindly see.
If he has not given so many reasons, in
No,
so many
no,
parts-
not so many, not even a single.
Very well. Let us see, sir.
Kindly see, Millard, the photocopy is there, Millard, in the.
No, you proceed.
Kindly see, Millard, the order dated 1st September 2021. That is the trial court's order. Not at the.
You want 0.75 acres also?
Also, because it was Millard allotment was initially for 25 and 75. Now Millard for 75, they are Millard after Millard.
Allotment was that.
Yes.
What now?
No,
subsequently
even
lease
possession
deed,
was
lease deed was in respect of what?
0.25. 0.25.
Allotment does not create
Allotment
any
was
right.
Millard 75 also, but total allotment was 1 acre. We took possession of 0.25.
Now you are only concerned with the 7.5. You want 7.5.
At
You want to compel the court to direct them to make over possession. Not possession is with you, assuming.
No. We have challenged Millard the enhancement. The whether they can charge Millard enhancement.
You are saying that has not been made over to you at the first.
Allotment is for one.
Allotment is something else.
We have taken possession of
Lease.
0.25.
Correct. Is a lease, Mr. Bhattacharya. There is a lease. Allotment lease succeeds the allotment. Now, a allotment does not translate into a lease. What will happen?
No, Millard kindly appreciates. There was a decision in their board meeting to Millard give us the land.
You want to enforce their decision?
Yes.
In a suit.
Yes, Millard kindly appreciates. Millard, it's not that we are Millard enjoying on a free. Millard, even for the rest 75, Millard, we are as of today, Millard.
I have a copy on Mr. Banerjee. Where is your junior? You will accept it?
24 years.
Yes, very well. I'll finish it off. Where Mr. Bhattacharya?
Immediately.
Having heard Mr. Bhattacharya,
Act has already.
Anna, one more day. Already initiated proceedings under PPI. Yeah, I'll finish.
Let me come back.
He filed appeal.
Tomorrow morning.
Tomorrow morning.
Yes. Tomorrow morning. First matter.
Tomorrow. Not tomorrow, but day after tomorrow. Wait test.
Kalke ki bar?
Wait.
15. You see, tomorrow is Sankranti. Then 15th.
Then it will be Shira Sankranti.
No, then 15th is not so good to evict you.
But not only this matter, his specific performance, he is asking after 20 suit filed by 20 years.
That will be decided.
And that was dismissed. Subsequently, another declaration injunction has been filed.
challenging.
Then serve the revisional.
Yes.
application.
Today itself. I've recorded he has accepted service. So after that, if he does not charge, I'm sure he will.
This will.
হবে না এখন তাহলে। এই February.
No, my lord, kindly fix it, my lord. Otherwise,
আরে I'll fix a date. February তে বলো তো কবে আছে একটা বলো। This month is very tight. It's very difficult. থার্ড ফেব্রুয়ারি কি সব ছুটি টুটি আছে না? হ্যাঁ তুমি সেদিন করে দেবে, পরের দিন তো পড়ে আসবে না, বলবে পড়িনি। 6 অনেক আছে। Fifth under the heading returnable motion.
Grateful.
You see, returnable motion has a different connotation. It will be taken up after those urgent motions.
In the supplementary list.
Yes. So you have a chance, urgency is there. I'll take up your matter. Yes, call the original side.
সবই আছে আপনার মক্কেলের কাছে, আমি যাই ওখানে 21 তারিখে ফিক্স আছে, আনিয়ে নেব।
Yes, sister. এই দরজাটা খুলে দাও না, গরম লাগছে। Wait. Let the audience side be called on. Wait. Let them settle. এই দরজাটা খোলাও না এদিকে। Yes. Yes, sir. I know, sir. Yes, on the last occasion we heard the matter. Your WS is on file but is not taken up. I will.
Like this.
So I remembered the facts.
Today is the date fixed.
Now. Mr. Sen, you have no objection if the opposition is saying WS is taken on record. After all, partition suit. And so far as the transfer, you are on transfer.
Very complicated about.
There is no complication.
It is a father.
May I request your lordship to have
That judgment of the Kalidas you have.
Well, may I have your lordship please looks at a written statement?
No, that is different issue. You have the judgment of Kalidas you have. He says very complex issues involved.
But there is no complicated issue here. 1951 Calcutta.
Yes, down.
No, there is no complicated issue here. If your lordship sees the written statement,
এটাকে দিতে বলো। এটা দিতে বলো, ট্যাবটা দিতে বলো। Yes, go to 5 minutes.
Yes. Well, there is no complicated issue in the
He
written
says
statement.
so. There is a. You won't say no.
Lordship sees the written statement. My learned friend is. Lordship has a look.
Yes.
Which paragraph of the written? I've gone through it. I have to go through it. Let my learned friend.
But you are not ready and willing to consent. But you still want the suit to be delayed. Then.
For last 2 years, they are taking time.
Not at all.
One time dismissed due to default. What is our fault, Kindly see the
Last.
prepare, Milord. As the ALP is pending.
খোলা থাক, খুলে দাও।
আমাদের এই জিনিসটা দেওয়ার জিনিসটা একটা করে সাথে আছে।
ওখান থেকে এটা দাও। বড়টা দাও বা কম্পিউটারটা দাও, তাহলেও হবে। কম্পিউটারটা দাও। কম্পিউটার নেই, বড়টা দাও। ওটা চলছে না, চার্জ নেই বোধহয়। চার্জ আছে, ছোটটা দাও। চার্জ আছে? দাও, চার্জ আছে কিনা দেখি। চার্জই দেয়নি তো, আগের দিন দেখলাম না।
দাগ না দেওয়া আছে? দাগ না দেওয়া কপি আছে?
It is. Wi-Fi to. দেখো হাত থেকে পড়ে না যায়। গরম লাগছে না? এটা পাখা চালিয়ে দাও না, এটা পাখা চালিয়ে দাও না, ওই দূরের একটা চালাও না, বা এদিকে চালাও। All on a sudden, there's a
very-
rise in the temperature, the day temperature. No, usually it was hovering around 23, 24. Today it looks like it is more than 27.
27 or not, but it's quite warm. And it's actually a little suffocating. Rightly,
Yes.
Lordship has opened the doors.
Previously, the doors were always open. Mr. Sen, you had seen.
No display board, doors
Nothing
open.
was
but we
there.
still
You used to
managed.
come in and find out which matter is going on.
Still managed.
And the corridors were little silent. Not this in this manner. Nowadays, you can see hear out whatever is happening on the corridor. Previously, corridors were. I won't
think
say
it
that.
has become very easy for us because of technology, but we have lost our discipline. We are finding
You
excuses.
never know. Maybe someone is arguing the matter standing on the corridor also.
Standing in the corridor.
Yes,
think
I
from
have
one-
seen.
one
I have seen from Jalpaiguri, people are arguing because in Calcutta, you see, people don't have the setup, the cabins, VC cabins. We have opened up 10 VC cabins in Andamans, 10 VC cabins, and there should be more VC cabins here as well, so that people get the opportunity to use that facility. Facility is available. Everything is online today. People don't have the access. There's so many advocates are there.
Not everybody has a smartphone.
Smartphone very well, but you need a space also. Smartphone with just a earbud will not really help you. You need a space, table space to sit around in a quieter room at least where you can argue the matter.
If your Lordship goes into the Bar Library Club and the small room,
Yes, now yes.
it now looks like an LCLT. Everybody is doing LCLT matters from the
I have
small
seen that. That was going on since 2021, perhaps. Yes, what is there in the written object, written statement? Let me find out. Yes, sir. You place your case from the written statement. Why is so complex?
That no intentional delay, my lord. It was plaintiff's case was dismissed for default, then miscase for restoration, 2-time amendment, and they served.
That is one thing that I have understood. You did not intentionally want to delay. What you have to say with regard to, you had said that there are complex issues involved.
The measurement of the house.
Measurement of the house, complex.
It's a survey will go. Survey will go.
Mentioned in the schedule to be lord.
Let my learned friend point out from the written statement where he has taken this point.
Let him show.
Yes, sir. I'll sit down.
Yes, sir. Show. Move your case. Which paragraph? Which paragraph you want the court to see?
Page number 80.
Yes, yes.
Of the incident application.
Page number
18
of the.
annexation of the.
No, what about your written statement? Where in the written statement you have indicated? Nothing. Very well. You want to go by the application. Fair enough. Yes. This is a suit schedule property. All that one-storied brick-built building standing on plot of land measuring 4 cutters, 12 cheetahs.
What is to be done?
Yes.
They have not given the copy of the said deed.
We don't have the deed. Where's deed is with you? Why it's an admitted position in the written statement?
No, do you say that suit property is a larger suit schedule property? Where have you said so in the WS?
We are now in the position.
No.
We are now in
Nobody is disputing your position.
and
But do you want the partition suit to go on?
we want to.
হয়নি তো এখনো।
They are giving out.
আচ্ছা।
We are ready.
Calcutta পরপর 3 খানা 10-13 যায়।
সর্বনাশ please. ঠিক আছে। Yes.
ফালতু সব প্রেজুডিশিয়াল যে পাঠ
Mr. Sen, what is the reference?
I think in 1951 on Calcutta.
The name of the case, Kalidas?
Remembering the name of the case. Getting तो पाए तो नहीं तो मोबाइल है तो पहुंचना
Is Kalidas Chakraborty? Yes, Kalipada Mondol, that is one. No.
हमने देख बैक पड़े इश्यू में बोले पड़े बैक टॉस करनी कौन दी
Kalipada Roy versus University of Calcutta, 1951 Calcutta, 129. I've got it.
Yeah, 51 Calcutta. I was just studying my juniors 51 Calcutta, but couldn't find remember. 51 3 khana clause 13 judgment.
1951 Calcutta 129.
Yes, my lord.
Yes, sir. Have you considered it? Please take it. You say it is complicated questions which cannot be decided. Sir, this goes against you completely, sir, if you say so.
Sir, here, the land in question belongs.
Sir, kindly come to paragraph 12 of this judgment. The court had set out certain objective tests and certain subjective tests. In paragraph 12, objective tests are set out. Do you have a copy of this judgment? Mr. Sen, kindly share with me. Address me going through this judgment, because this is the judgment which I shall generally the courts follow. The case involves difficult points of English law such and such. The matter in disputes are mainly questions of law which can be tried more conveniently and better in a high court. Then there was very little evidence to go into. The matter involves construction of deeds such and such, question of difficulty arose such and such. These are the objective tests. And paragraph 13 is subjective test. Subjective test is perhaps not relevant consideration here.
But the test will apply in the facts of the case. Now, Lord, my learned friend is talking about if your lordship had filed a supplementary containing the orders of the trial court, your lordship will find that after they file the application for Lord recalling the order for ex parte hearing, thereafter my learned friends have been quite uninterested in the matter there.
There is a delay of this is a partition suit. Your WS will be taken on record, and I have ascertained from here. Now, if you consider this, if you give consent, I can immediately transfer it. Otherwise, your objections, you say that I have considered your case on merits. That's why I asked you to take instructions in the matter.
I have taken the instruction.
You are not, so you want to delay the hearing of the suit then.
We are
Then
ready to.
matter is pending since which year?
2018.
Huh?
18.
2018.
7
No
years.
progress.
7 years.
They
WS is not on record.
Yes, my lord. They filed the and it was dismissed due to.
That's a long time back.
His case.
That's a long time back.
That was allowed after 2 years. Then time amendment was made by the plaintiff.
28th of February, 28th of February 2024.
The time petition, my lord.
28th of February 2024, the court recorded that in view of the written statement not being filed, the suit would be proceeded ex parte against the defendant number 1. February 2024. And thereafter, the plaintiff has gone and has deposed. Evidence has been taken partly. Then they filed an application for recalling the order for ex parte hearing, and it is pending at the stage of hearing of the application for ex parte hearing. And they because the matter is fixed today. That is why, because we don't want to overreach the court.
Naturally, they will take time. You chose not to file your written statement for so many years. When did you file? When did you file? After the evidence was laid. Sir, please understand the situation. What are you submitting, sir? You have delayed the proceedings for all these years. Now you are saying today they are taking an adjournment because the matter is here before this court.
Kindly see, all the time they are serving in other address. After Honorable Justice Shankar Sarkar issued the rule, it was served.
Till February 2024, written statement had not been filed. In desperation, the court fixed for ex parte hearing. Thereafter, evidence has been taken partly. And then they filed, and thereafter they are now proceeding with the hearing of the application. We want to get rid of all these procedural technicalities. And what is the defense taken? The defense taken is that since the daughter has got married and has gone to her matrimonial home, therefore the father is not interested to give the property. In fact, the father had passed away long before the marriage. The property was of the father's. Father did during his lifetime. There was no question of marriage also.
Where do I get that the suit has proceeded up to the stage of evidence?
If your lordship takes a supplementary affidavit that we have filed with the order sheets. If your lordship is pleased to take the supplementary affidavit, which is affirmed on 6th of December 2024. Your lordship will find the first date on which
2023, they revived the state case, on 4th.
Lord, if you please takes the revisional application and takes the order sheet action direct to body 6th August 2019. The order sheet and in the revisional application, order dated 6th August 2019.
Yes.
Today is fixed for appearance plaintiff files Hajira, dependent does not appear before the court till now 4 p.m. So the suit runs ex parte against the defendants. 6th August 2019. Since then, it has been proceeding ex parte, and your lordship, if your lordship has been.
In the year, Miller, kindly see page number 49 of this application. The order dated 4th March 2023, where the miscase for restoration of the said suit was restored.
Correct. I am not disputing that.
After that press, someone was issued which return answered.
So you are not aware of this. You are not aware of the suit.
Someone was given.
So when was the suit dismissed?
The suit was dismissed in the year 2019.
Today is fixed for appearance.
Now,
after 6th August.
After this August.
Very well. So by this time you were served with the copy of the summons?
Miller, suit summon was not served. It was served in the year 2020.
6th August 2018, defendant does not appear. Kindly see, it runs ex parte.
The minister was running from 2019.
Please understand, once you have been served with the copy of the summons, second time also you will be required to be served with another set.
When the suit was
So it is dismissed, running into ex parte board, matter is dismissed. Where is the requirement of service on you further?
when it is restored.
So for you are coming to move a revisional application before this court. There is no caveat endorsement. The court dismisses the matter. When you come up for restoration, the court will direct you go and serve them and come back. Or consider a different situation. You have filed a suit, failed to obtain an ex parte ad interim order of injunction. You prefer a miscellaneous appeal. The miscellaneous appeal is dismissed. You file a restoration application. The court will ask you, first serve and come.
Lower court, they have to.
No, sir. Never, sir.
Now, my lord, if your lordship will find a fix for ex parte evidence, I have shown your lordship.
Yes.
Now, my lord, please come to the order of 27 January 2021. It's part of that order sheet, my lord. 27 January 2021. This is a handwritten order, my lord. After 3 or 4 or 5 pages, there are several pages of lawyers not appearing
I've got it.
because of this. This is where, my lord, the suit was dismissed for default. Now, my lord, the very next page, your lordship will find application under Order 9, Rule 9.
So you also did not appear on that date. On 21st January, you did not appear. Please understand, sir, you are making submissions that the plaintiff did not take steps. Very well. How are you concerned? You did not appear.
I am not the plaintiff.
You are the defendant in a partition suit. Suit is for partition. So you are placed in the same footing as the plaintiff is. Unless you say, I don't want partition. Unless you say, I don't want partition.
Your lordship will find the restoration order is 4th of March 2023. 4th of March 2023. Several occasions time is given. Ultimately, on various grounds, it is not taken up. But 4th of March 2023. That's because of change in the some address problem.
In the
Problem with the address.
restoration application also amended. Restoration application filed by the plaintiff was also amended.
Your lordship will find your lordship has seen 4th of March 2023. The suit is restored.
Made by the plaintiff.
At second page of the order, ordering portion, original suit number 712 be restored to its original file and number. Then, Lord, next page, 8th of March 2023 onwards, your lordship will find fixed for ex parte hearing of the suit because of the absence of the written statement right from the beginning. It was fixed ex parte earlier, now that is continuing from 8th of May 2023 onwards.
They have changed 7 advocates.
Arey Baba, we can have 59 advocates. How does it matter?
7 advocates.
আপনার অসুবিধা কি সুদ তাড়াতাড়ি শুনানি চাইছেন না তাহলে ওখানে তো দিনের পর দিন টাইম নিয়ে যাবেন আসছেনই না তো আপনারা
লাস্ট 1 বছর তো আমি তো দেখালাম একই ফরম্যাট একই জিনিস আছে
But after this, if your lordship kindly takes the supplementary affidavit. Supplementary affidavit copy nahi?
Where is your show cause? Ajay, please, you complete first.
Lord, please take the supplementary affidavit, page 4, 6th of October 2023. Your lordship will find this is the amendment my learned friend was talking
Such a
about.
detailed order, 4th March 2023.
No, 6th of October 2023, my lord.
No, I'm saying such a detailed order.
6th of
Restore
October.
the suit, 4th March 2023.
Yes.
So it is only thereafter you thought it fit to go.
No, thereafter also is proceed. No, thereafter also it's proceeding ex parte. Now, Lord, after this is a supplementary affidavit.
Yes.
If your lordship please takes a supplementary affidavit, page 4, we had filed an amendment application because of not the premises had been renumbered by the corporation. My client does not reside there. My client resides in a matrimonial home. For that, Lord, page 4, 6th of October 2023, today is fixed for ex parte hearing of the suit. Then seen the petition, the large paragraph is with regard to the amendment of the suit property, the scheduled property. It had been renumbered as 643 Lake Gardens. That was allowed. Then your lordship will find fixed file for filing of rectified plaint. Then Lord, please see two important orders. 10th of January 2024. Track reports are showing that summons have been delivered to the addressees.
Yes, sir.
Page number, line number 3.
2000
দাঁড়ান দাদা একটু শেষ করতে দিন, আপনি তাড়াহুড়ো করছেন কেন? Have some patience, please sit. Defendant number 1 appeared this day, filed a petition for time for filing WS along with a prayer for direction upon the plaintiff for serving copy of the plaint upon defendant number 1. Defendant number 1 also undertook to file Wakalat number. Defendant number 2 and 3 did not turn up. Regular, etc. To date,
PPO is cancelled.
to date for appearance of defendant numbers 2 and 3 positively, ID ex parte. Now, Lord, please come to the next two orders. 5th of February 2024, today is fixed for filing Wakalatnama. Not fourth line, defendant filed number 1 filed petition praying for time for the filing WS along with a separate petition filing Wakalatnama. Defendant numbers 2 and 3 did not turn up. Let the suit be proceeded ex parte against defendant numbers 2 and 3. Next page, your lordship will find same thing so far as defendant number 1, who has been asking for time to file WS on the last 3 occasions. He also did not turn up. 28 February 2024. Today is fixed for filing Wakalat number by defendant number 1, positively by defendant number 1. Plaintiff files Hajira. Defendant number 1 took no steps today. Defendant number 1 did not file any Wakalat number till date. Hence, the instance to be proceeded ex parte against defendant number 1. So 1, 2, and 3 against all of them, it became ex parte. Then, Lord, 16th of April, they file an application for, Lord, vacating the order of ex parte hearing. Then your lordship will
It's
find
still in the ex parte board.
ex parte board and plaintiff has given evidence. Plaintiff has given evidence. Part evidence has been taken. Part evidence has been taken orally before the court by the
It is
plaintiff.
still in the ex parte board.
Still in the ex parte board.
So there is no written statement filed by you.
No written statement.
Yes, my lord, we have
Read-
filed it.
No, it's not on record.
Sir,
It's just filed.
unlike the High Court, where unless you get the leave, written statement cannot be filed. Before the trial court ordinarily, whatever document you want to file can be filed. But that is subject to acceptance by the court.
Yes, my lord, it is fixed for aspect.
Correct? So therefore, the written statement that has been filed by you has not been accepted by the court as yet. So the matter is proceeding ex parte so far as you are concerned.
But I'm giving the concession that that can be taken on record if my learned friend allows that suit to be heard here. Lord, please take 23rd August.
Not
Please,
yet.
no, we'll come to the 23rd of August 2024. Plaintiff files Hajira, witness is present today and examined in part as ex parte. Documents have been marked Exhibit 1 to Exhibit 3. Then case is adjourned. Then Lord, next page. Then we filed Hajira along with supplementary affidavit in chief along with documents as per Firisti.
Examined in part.
Examined in part, Lord. On 23rd of August 2024. Next date, 9th of September 2024, we filed further documents with the Firisti along with supplementary affidavit of evidence.
Plaintiff
And thereafter, Lord, on 29 November 2024, defendant appeared this day by filing a petition for vacating the order of ex parte hearing and show cause petition with copy. But none moved for the defendant on repeated calls. 29 November. They moved and then went away. Like in the morning, we filed the Hajira and they go away. Nobody appeared at the call. 29th November. About today's matter, he is next here.
application that one AAP is pending before the High Court.
Naturally, we can't overreach the Honorable High Court.
when did you receive the copy of the show cause? Very well, let him complete. That is all.
That is almost, thereafter, the matter is before your lordship, my respectful submission is that the shares are admitted. Now, if your lordship takes the written statement which is intended to be filed, there's only one place, or rather only one point which is taken. If your lordship please takes the written statement which has been made over to your lordship. Now, the first line itself, the first line of the written statement itself is an admission of our right in the property. The plaintiff is daughter of the said late Dilip Das Roy, along with defendant number 1, husband late Devashish Roy, are the owners of the property.
Yes.
The defendant is daughter of late Dilip Das Roy, along with the defendant number 1's husband, late Devashish Roy, are the owners of the property at such and such Lake Gardens. The said property, which is more particularly mentioned in the schedule hereunder written, is the subject matter of this suit and hereinafter referred to as a suit property. But this statement is very much disputed about the ownership of the plaintiff's part, as said plaintiff was married and went to her matrimonial home, and the said Dilip Das Roy declined her share and gave entire property to his son Devashish Das Roy. As their mother Uma Roy died on such and such, Dilip Das Roy died on such and such. Now, if the father wants to deprive the daughter, it can be either by if father wants to deprive the daughter, it can be either by a will, which will take effect after his demise, but which has to be probated, no mention, or it can be a gift inter vivos. Neither of the two are mentioned, neither of the two are brought on record, no whisper of that. The allegation is that because she got married and went to her matrimonial home, therefore she is not being given the property. As a matter of fact, when the father died, she had not even got married. She was unmarried at that point of time. There is no other point taken in this entire written statement. No other point. Let us assume, for the sake of argument, that they will bring something to the court to show a will, unprobated or a gift. That will be decided by the court when the preliminary decree is being granted. When the preliminary decree will be granted by the court fixing the shares of the parties, that will be gone into at that stage. How does that affect the maintainability of the suit? Even if the suit is not maintainable, it will be decided by the court deciding the preliminary decree as to what is the shares of the parties. If the court finds that the plaintiff has a share, then an advocate commissioner will be appointed. And I've told your lordship, not even on earlier occasions, that if there is some old properties may not be exactly half and half, we are willing to take a lesser share. But let this matter get settled once and for all, so that the dispute between the sister and the brother's family does not continue. Because this is a festering wound. We want to bring a closure to this family dispute. And this can only be done by a partition which can take place either by commissioner of partition saying, yes, it can be divided half and half by meets and bounds, or somebody will take more, somebody will take less, we are willing to take less, or we are willing to pay OLT money, whatever. We don't want to enter into any dispute with regard to any technicalities. Now, ultimately the matter will come to the High Court. We want to ensure that the few years that will transpire in the lordship has seen 7 years have expired. No, we are not on Howrah. There's only one partition suit, only one property. This is the only property. No, these are my respectful submissions, brother.
Yes, sir. You can submit. Yes, sir.
Several letters.
Show me which letter.
We got information from my client of Uma Das. After the death of.
Where is the where are the letters? Show me letter. Which letter? Then you want this court to consider certain letters.
I am just.
No, then don't make submission unless you show me something. Sir, what is the issue today before this court? The issue is whether the suit which has been pending since the year 2018 before the learned court should be transferred to this court or not. What facts do I find? I find that the suit was filed in the 2018 and the suit was running ex parte. I find that the suit in the interregnum had been dismissed. Subsequently, application under Order 9, Rule 9 was filed and the suit was restored. You had at no point of time appeared. Thereafter, I find after the restoration is there, the court calls upon them to appear and lead evidence. Thereafter, the defendant number 1 appears on a particular date. You do not appear. You are not the defendant number 1.
I'm the plaintiff. I'm the plaintiff.
You are defendant number 1, 2 and 3 also. Very well. So, very well. So, defendant number 1 appeared. Defendant numbers 2 and 3 did not appear. Partition should mind you. Very peculiar circumstances. It is not that one person knows and the other person does not know. These are the facts.
To explain that the defendant number 2 at that time was studying at Amity University, he's out of station, and defendant number 3 was studying need joint at Kota. That's why they are outside Calcutta, so they could not appear with the defendant number 1, but on the later occasion, when they came, they were.
Where is your application to that effect? What you said, where is your application for removal of the matter from ex parte board?
We have made the application.
Where is that? Show me. Today is 4:30. Come tomorrow, show me. Show me that application. Conclude. He has already heard. I have already heard him. You can bring the applications tomorrow. Show me the applications tomorrow. Heard Mr. Sen, learned advocate representing the petitioner. Release this matter for further consideration on the same meeting tomorrow or day after when you want it. এই ওই মামলাটা কবে আছে না? এদের মামলাটা একটা কবে আছে না? কালকে আছে, ওটা হবে না তাহলে। পরশুদিন কি আছে? Day after. There is one more matter, Salasar, so that will continue. কবে আছে ওটা? রত্নাঙ্গ ব্যানার্জি এটা করছিল, সেটা কবে আছে? পরে আছে। এটা এই সপ্তাহে করে দেবো শেষ।
My lord, may I have your lordship's kind indulgence?
My lord, before your lordship rises, my lord, item number 89.
Next matter.
My lord, may I have your lordship's kind indulgence, my lord, with regard to item number 8 and 9? With regard to item number 8 and 9, my lord, may I have your lordship's kind indulgence? My lord, may it be taken up on Thursday subject to my lord's convenience? I am for the official liquidator.
It is there. Let us see.
Today, my lord, day after tomorrow, I will be out of station.
I'll not dismiss it. I'll not dismiss it. It will be there in the list. Hey, ওটাকে নিয়ে নাও তো।
The next matter, item 2.
Yes.
Item 89. But item 2, my learned, we had served a copy of this clause 13 application on my learned friend who was appearing for as the advocate in an appeal.
Yes. Sir, you have lodged a caveat.
I tried to contact my counterpart in the court below.
What is the matter?
Clause 30, we are wanting a suit to be transferred from Uluberia court to. There are 4 directions for expeditious disposal, 3 in appeals, 1 in a revision.
Take instructions. Sir, I'm not passing any order today. I cannot pass any order. You take, cannot pass any order if I want to also. It's today, I'm not passing. Consider and come.
My lord, item number.
এইগুলো আপগ্রেড সকালে আপগ্রেড করেছি, এ নাও কটা আছে দেখেছি।
My lord, item number 89, my lord.
নিয়ে না ওটা 89 টা ওর ডকুমেন্ট দেওয়া ছিল।
My
Appellate
lord,
side
case
to-
status and the order under review, my lord, both have written.
But if your lordship kindly directs my learned friend to take instructions and if there is an order to that effect, then my lord, we can.
I cannot compel him, Mr. Gupta. I cannot compel him. I have told him. I cannot compel him. No, I cannot direct today. Today I'm not directing. If you can, you take instruction. If you cannot, you cannot. I cannot compel him. You understand, Mr. Gupta? If he'll inquire. If his client says no, can he say no, I will appear? There are difficulties also for him. How can he compel? How can he say that no, you unless he says that the court has engaged me? Why will a court engage some private individual in a private matter? I understand, but if there are difficulties, he is also facing this difficulty. What can be done?
Otherwise, there are 10 opposite.
What will he do, sir? Yes. না কি করে অর্ডার আসবে না পরের দিন হবে যখন পরের দিন যখন হবে তখন দেখা যাবে